May I please your lordship? Madam, there is some pasture land, gochar land, taken by the opposite party number 4 to 18, so that it is difficult to grazing the cow and moving.
According to you, public land has been encroached.
My lord, this is government land. Government land.
You could have filed. Is there any?
And I have filed the petition before the Tahsildar.
When did you approach the authority concerned?
My lord, that is annexure 13, page, annexure 3, page 13.
When?
Before the collector on 21st August 2021. Thereafter filed the petition before 2022. Now it is listed. I had filed this petition in the year 2022. It was listed now.
Take a call.
My lords,
Who has to decide?
my lords, Tahsildar has to decide that whether there is any encroachment, and if there is any encroachment, necessary steps should be taken. But if your lordship will find, the representation was filed in 2021. Writ was filed in 2022, and it is listed in 2024.
Yes.
So in the meanwhile, and there is no acknowledgement of receipt of this representation. So let him make a fresh representation to the concerned Tahsildar, and your lordship may direct to consider that representation in accordance with law.
Is the external grievance. In fact, it is in your interest. You should have, once it was made known to you that this is a public land which has
Yes,
been
my lord.
imposed upon.
Yes, my lord. That is
Upon by persons, then you could have taken a step without waiting for any representation or an order of the court.
that can also, if your lordship will issue such a direction, that I can ask the Tahsildar to take necessary steps.
How many petitioners are there? The petitioner has approached this court by filing second writ application in the nature of public interest litigation with a grievance that a public land in the nature of gochar bracketed pasture land has been encroached upon by
Opposite part number 6 to 17, 18, 6 to 18.
the opposite party number 6 to 18. So stop. The description of the land has been given in paragraph 1 of the writ petition as under quote unquote Moja de Langa, paragraph 1 say. So, this is the petitioner's case that he had approached the concerned Tahsildar of which place?
Tahsildar.
Opposite party number 4.
Opposite part number 4.
Opposite party number 4 by making a representation in 2021 itself, but no step has been taken so far. So next, whether the land in question is a public land or not, should be a government land or not, should be considered by the Tahsildar in view of the grievance which has been raised in the present writ application and the petitioner's representation before him. So it goes without saying that if the land in question is found to be a government land illegally encroached upon by people, the competent authority shall be legally bound to take appropriate steps in accordance with law. So next, we make it clear that this order has been passed, present order has been passed without hearing the private respondent.
Private respondent. Yes, madam. Opposite part number 6 to 8.
Private respondent. So we have not gone into the merits of the contentions in the writ application. So any observation made in the present order shall not be treated to be court's opinion by court's opinion on any aspect. So this application stands disposed of accordingly.
Item number 2.
May I please your lordship? My lord, in this matter, the order of the Honorable Supreme Court is in flap B, where the,
File your affidavit. File affidavit, supplementary affidavit.
my lord,
All right. How much time?
1 week time,
This is the case which was withdrawn.
my lord.
This is- Yes. It was earlier withdrawn
My lord,
and thereafter you filed.
another writ petition by implementing the necessary parties, and that was being dismissed on the ground that the earlier petition has been filed. Now in this order, the Honorable Apex Court has relegated the parties before the Honorable High Court by restoring the present writ application to be decided afresh. That is in paragraph 10 of the order.
Where is the order passed in 32370 of 2022?
My lord.
Yes, you had withdrawn.
My lord.
You had withdrawn the writ petition.
My lord. Withdrawn to implement the necessary parties and to file the fresh
You
application.
file your supplementary affidavit. How much time?
1 week time.
1 week? 3 weeks. File within 1 week, the matter will be listed after 3 weeks.
My lord.
Item number 3.
May I please, Fellows? My lord, here the case, the background of the case is like this, my lord. There was an advertisement for filling up the post of assistant professors by OPSC in government medical colleges, and the advertisement was issued in 2016.
So file your affidavit first.
My lord, this is the appeal. Appeal.
Huh?
Appeal, there is no affidavit.
Oh, this is appeal, no?
My lord. My lord, the petitioner applied for the post of assistant professor in the discipline of microbiology.
Just a minute.
My lord.
Where is the order?
My lord, order at page
42.
42, my lord. Also, initial order is at 39, my lord.
No, final order is page 42.
My lord. On 39, my lord, this case, in fact, needs a sympathetic consideration of my lord, because due to fault of the advocate, or some miscommunication, this order was passed saying that this case is infructuous. That's why I am starting placing the case. In fact, it was not infructuous. It's a wrong in the part of the advocate. That's why the petitioner is going to suffer. May I place the background of the case, my lord? If my lord feels that this is not infructuous, then I don't have a case. In fact, it was not infructuous. In fact, the case was not infructuous, my lord. May I place, my lord, a small background of the case, my lord?
Yes.
Well, there was an advertisement in 2016 for assistant professor in different disciplines. The petitioner applied for assistant professor in microbiology. Her candidature was rejected without any specific reason, saying that these people, those who don't have any required qualification as per the advertisement, their candidature was rejected. While the petitioner approached the Learned State Administrative Tribunal, where the case was admitted, interim order was passed, and notice was issued, my lord. And in the meantime, my lord, that post could not be filled up by any doctor. Another advertisement was issued to fill up the post on contractual basis. This petitioner got selected, and she is continuing in the same post till date on contractual basis. In the meantime, the Learned State Administrative Tribunal was abolished. The case was transferred subsequently to this honorable court. My lord, the notice was issued. Interim order was passed. The only thing was necessary that the government or OPSC was supposed to file that.
This appeal relates to which selection process? The first selection process?
My lord, my lord.
So that has been done away with, that
No.
has been cancelled.
No, that was not cancelled.
Then?
No one could. My candidature was rejected. The person who was selected, he didn't join. That was vacant. For that, an appointment was made on contractual basis. And this petitioner got selected, and she is continuing till date. And about that selection process, that was before Learned Tribunal. Interim order was passed, notice was issued. Counter was supposed to be filed, and case was supposed to be heard. But what exactly happened when that was transferred to this honorable court? Somehow it was presented before the court that the case has gone infructuous. In fact, it was not infructuous, and on that basis it was dismissed as infructuous. What I only pray is that, merit is single chance of hearing. Maybe this case may be hard on merit. That is the only prayer I have. This is the case where she has a very good case here.
Who is for the commission?
For the commission, my lord.
My lord,
The commission is the necessary part.
my lord.
Lord, I am appearing on behalf of Mr. P.K. Mahanti, Senior Counsel, my lord. Lordship may hear the matter on merit, my lord.
I don't understand.
Lord, we have also filed, my lord, may kindly refer to the advertisement for a moment at page
Just let us
15.
know
my lord.
whether in fact his writ petition had become infructuous when the
Ma'am.
order was passed.
Ma'am.
This is the only question.
Lord, at that time on his submission, my lord,
For
it
which
was-
submission?
my lord. Actually, it has become infructuous because this relates to the advertisement of 2016, my lord. And my lords, after 1 year, my lords, the OPSC becomes functus officio after recommendation. Everything was
No,
over.
recommendation was not made in his case.
No,
She was not selected because she did not, my lords, she was not eligible in terms of the advertisement. And also as per the rules, medical rules, my lord. We had filed the counter
But
also.
he's saying there was some interim order passed.
my lord.
My lord, regarding interim order, my lords, we have filed the counter at page,
You just take specific stand on the next day,
my lord.
whether his writ application was
I will,
become infructuous.
my lord.
All right. Take a specific stand whether yes or no.
Yes, my lord.
All right. Either by virtue of lapse of panel
Yeah.
or
My lord, only interim order will save me, my lord. Only if there is an interim order, then that would not be infructuous, my
we
lord.
don't know.
My lord, my
We
lord.
don't know. Let him take stand.
My lord,
If he says that the writ application had not become infructuous, according to him,
my lord.
then we will see.
Deeply.
All right.
My lord.
How much time will you take?
My lord,
Because you have
1 week.
to make your submissions only.
My lord, 1 week, my lord.
As requested on behalf of the Odisha Public Service Commission,
My
My
lord.
lord.
this matter on 1 week within first 5 cases. From the court would expect learned counsel for the commission to take specific stand before this court as to whether the petitioner's writ application had in fact become infructuous on
23/9/2022. The day on which the order was passed. 23/9. 23/9, 2022, my lord.
22, when his writ application was, his or her, when the petitioner's writ application was dismissed on submission made on behalf of the petitioner to the effect that the same had become infructuous.
Ma'am.
You will see.
Ma'am, deeply opposed.
Item 4,
May please, let's see. But challenging rule 4 of the 22 rules, I have filed this application. Challenging, my lord, rule 22 of the Group C, Group D employees, I have filed this application. Minimum 200 matters are pending for the honorable court. May I pay, my lord, this
That
matter
rule is ultra-virus.
to rule to ultra-virus, my lord.
Ultra-virus what?
The contractual appointment rules 2022,
This, you, according to you, the rules are ultra-virus.
my lords,
I've seen your writ petition.
my lords.
Ultra-virus what?
To declare
Ultra-virus, any act, any provision under any other act. Ultra-virus, the constitutional provision. Ultra-virus means you cannot say simply that this thing is ultra-virus. You will have to say ultra-virus this provision, ultra-virus that, the constitutional provision.
my lords, I am challenging here the contractual appointment rules 2022.
You are challenging some statutory provision.
My lords,
So we'll have to take a stand that this statutory provision is contrary to some statutory, other statutory provision.
my lords,
You cannot challenge statutory provision like that. The rules are under challenge.
My lord, in similar cases,
Whether the rules are under challenge in other cases.
Other-
How many cases?
there are batch of cases, my lord.
All right.
Yesterday, my lord's board, item 8 was similar matter.
uh, This matter along with. So, they can supply. When are those cases?
my lord, WPC number 9791 of 2023.
All right.
item number 5,
Lord, I want times.
Time,
Times.
supplementary affidavit.
Oh,
File supplementary affidavit. How was time?
after 2 weeks.
2 weeks. Then counsel for the.
In item 5, my lord, in item 5, advertisement of 2014 is under challenge. Advertisement of 2014 is under challenge in 2023, and the recruitment process is over. Everything is over.
Then why are you pressing?
My lord,
2014 matter. what-
Advertisement of 2014, and the meantime recruitment is over.
Why should you pursue? All right, we will wait for your senior is to appear in this case. Huh? कौन appear करेंगे? Who will appear?
my senior will appear.
Your senior. So we will take up the matter tomorrow on Thursday. All right. There is nothing in it. So why should we keep this matter pending unnecessarily? All right. We are adjourning only for the reason that the blame may not go on you. Otherwise, we would have dismissed it. We requested on behalf of the petitioner this matter on Thursday. Petitioners.
Item 6. Item number 6.
May I please, Lord, sir.
Yes, please.
Yesterday I was submitting to your lords.
Yes, it's covered, sir.
It's covered because the
Let's say,
judgment has been set aside by.
let's say kindly see paragraph 4 of that judgment. Paragraph 4, my lord. Considering the submission, let's got it.
Which page?
Page 7, my lord.
Right.
Considering the submission made by the Lord and Senior Advocate appearing on behalf of the petitioner and looking to the factual and legal aspects of the case, this court finds that the committee constituted by the National Green Tribunal has violated the principle of natural justice by not affording the petitioner an opportunity of hearing in such view of the matter, while setting aside the impugned order dated 18/4/2023 under Annex 2. This court remits the matter back to the National Green Tribunal, Eastern Zone Bench, Kolkata, for adjudication of the issue appraised. It is also made clear that the committee constituted by the National Green Tribunal, Eastern Zone Bench, Kolkata, shall afford a petitioner reasonable opportunity of hearing first, and thereafter the National Green Tribunal, Eastern Zone Bench, Kolkata, shall pass order in accordance with law. My lord, this is a case, my lord, relating to the illegal extraction of ore, my lord. Illegal extraction of ore, my lord.
No,
And this one no court.
How is this order connected with the present writ application? The relief is the petitioner is seeking in this application.
My lordship can say annexure 5.
Let me explain, my lord. Let me explain.
Annexure 5.
Lord, just a
Please,
minute.
please, let him ask.
Lord, I am a construction contractor, was entrusted with the work for widening of the National Highway number 16 from Bhubaneswar to Tangi. That's over 60 kilometers road. And I was granted certain permits for extraction of ordinary earth and moram, because these are the materials which would be used for the purpose of road construction. But some interested party, they moved the NGT in Kolkata. So they constituted a committee, Mila. That committee, first of all, conducted the field survey in my absence, behind my back. So I took that plea before the NGT that I have not been given opportunity when the alleged measurement took place. So thereafter, I came before this court against the final order. That was by virtue of an interim order by the NGT. I will place that order. Your Lordship may kindly turn to page 46, Mila. Para 13 of the order. We therefore direct respondent number 15, Director of Geology, Bhuvigyan, Para 13 of the order of the NGT. This is an interim order. This is not the final order, has been quashed by the Para 13. We therefore direct the respondent number 15, Director of Geology, so and so, Khurda, to file his personal affidavit in this regard to meet this allegation, and he shall also determine if there has been any illegal extraction of moram, etc. And if so, what action has been taken for recovering the cost of illegal extraction. But pursuant to this order, the page 48 your Lordship would find, an inspection was allegedly done in my absence, and measurement was taken by the committee by the help of bamboo miller. That is the yardstick for measuring the illegal extraction that your Lordship would find the next page. But the fact remains that I was not given any opportunity while the so-called inspection team visited the spot and took up the measurement, etc. Your Lordship would find at page 49. I am only one query, Millard. There is no illegal extraction. Some other Millard leaseholders, they have done. I am not connected with that. There were because 3-4 queries like this were partly submerged with water during the time of survey. That I failed to understand, when the area is submerged with water, how can the measurement be taken up? And that too by, however, the spot RL were determined with the help of bamboo miller. That is a measurement criteria. Anyhow, apart from that, I moved before this honorable court that there has been flagrant violation of the principles of natural justice. This honorable court was pleased to set aside and remit back. And this entire demand pillar is based upon this inspection report, which forms the basis of the impugned demand.
Where is
So that is why we have to wait till the final.
Where is that?
Your Lordship would find, your Lordship would find the annexure 5 series at page 56. This recommendation is at the back of this inspection report. Your Lordship would find
The impugned
at
order is
page, impugned order is at page, my lord,
56,
annexure 5 series, my lord. This is the demand.
56 million.
56 million. They refer to the collector's letter, and the collector's letter is based upon this inspection report. With reference to the subject cited above, I am to inform you that the collector Noyagad has directed to realize the cost of illegal excavation of Moram ordinary
No, but
soil.
how do you say that this order is based on that report or the order passed by NGT?
This collector's letter is not there with us. He has referred to this letter, Mila. This letter number 1794 dated 30/11/2022 as per the order dated 26/8/2022. If your Lordship would look at the inspection report, your Lordship may kindly turn to, I forgot to point out, in connection at page 48 again, annexure 4. In connection with National Green Tribunal Eastern Zone, Kolkata, page 48 I am placing. Page 48.
Yes.
Did my guess. In connection with National Green Tribunal Eastern Zone so and so, application number, Director of Geology, respondent number 15 has determined the illegal excavation of laterite so and so in Mayurjhalia village of plot. As per letter number 29/9/2022, the Tahsildar Ranpur District Noyagad submitted the cadastral map indicating so and so lease, etc. Milord, this is pursuant to this order. This committee, Milord, visited this spot. That is in pursuance of the NGT order, Milord, which I placed just now. So after this, Milord, the fact remains that the rule, your Lordship knows that the natural justice demands, if it ensues civil consequences, which is in the nature of penalty, Milord, the agreed parties should be given an opportunity of hearing. That is the what the purport of Bina Pandit and Mahendra Singh Gill. You can't ensure, Milord, if the civil consequences has to follow. It's a penalty. That the measurement is to be done in my presence or in the presence of my representative. They did it pursuant to the NGT order, and that NGT order has finally been struck down by this honorable court. And
When was this writ petition filed? When was your this writ petition filed?
This writ petition was filed before that, challenging the order of the NGT on the ground of excess jurisdiction. This was filed on 9/10/2023, Milord. This judgment of the honorable.
Have you filed your counter affidavit?
No,
Now this has come first time, man.
This is comforting.
Let them file counter
This is
affidavit.
January order, Milord, 2024.
Okay.
It's subsequent to the filing. It says
In the meanwhile, we will still operate. All right.
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 I have been granted permit by the Tahsildar. There has been no excavation from my area. They visited the spot which was waterlogged. And that too, Milord, if any.
From there.
No, there are 4 queries. 3 other leases are there. My query is query number 1. The entire area was submerged with water. That is what the committee also finds. But if at all they took any measurement, that has to be done in my presence. They can't unilaterally do it and submit a report, even though NGT didn't direct to.
Mr. AGA, accepts notice on behalf of opposite parties, all the
Right.
opposite parties.
Milo.
Director of mines also.
Milo.
You will take notice on director of mines.
Milo.
They're all government bodies.
All government.
Government terms.
On behalf of the opposite parties and thus waives service of notice upon them. Stop. Next. London Senior Counsel appearing on behalf of the petitioner has drawn our attention to an order passed by a London single judge of this court dated 8/1/2024 in WPC number 26730 of 2023, whereby an order dated 8/4/2023,
24 minutes.
18/4/2023, passed by whom?
Passed by Honorable Justice S.K.
No, 18/4/2023 order passed by
NGT.
My lord, NGT Kolkata bench, Eastern bench Kolkata.
the
Eastern
NGT
bench.
by the NGT based on an inspection report dated 11/11/2022 has been inspection report submitted by a committee dated 11/11/2022 has been set aside on the ground of breach of principles of natural justice. First off, he has submitted that the impugned demand notice dated 10/1/2023 in the present writ application application has been issued in the light of the inspection report, said inspection report dated 11/11/2000 has been issued based on the inspection report of the committee dated 11/11/2022 and therefore 22, which has been a report which has been held to be inspection report has been set aside,
No, but the whole judgment has been set aside. That forms a part of this.
which a report which has been held to have been submitted in violation of principles of natural justice by the learned single judge in the aforesaid order dated 8/1/2024. Stop. Next, after having gone through the contents in the writ petition, pleadings in the writ petition, and submissions advanced on behalf of the petitioner, we find substance. We are prima facie satisfied with the submissions so advanced. Stop. Accordingly, till further orders, the operation of the impugned notice dated 10/1/2023 shall remain stayed.
Deeply obliged.
The
Annexure 5 minute, Annexure 5 series.
Annexure 5 series.
Series, minute 2, there is also a further reminder. So that is, we have, instead of making it 5
When
sets.
10/1/2023
That's
is
the
stayed, then
yes.
everything is
That's
stands.
obliged, deeply obliged. But that is to be read with IA number, because we
The-
separately
let the
make an
counter
interim
affidavit.
application.
Yes,
We separately make an interim application, IA number 16641. Not here also the practices, we make
Alright.
it separate, not in the
INM.
deeply obliged.
Just a minute. let counter affidavit be filed on behalf of the state on behalf of the opposite parties within 4 weeks. Stop. IA number so and so stands disposed of. IA number, what is IA number?
IA number, the last page 11.
Huh?
Not 1 second.
16641.
41. Right.
So while putting such questions, I am also trying to know the system of the.
That's correct. That's correct. But in Supreme Court, ordinarily the interim prayer is made in these SLP and other high courts also, but we make a separate IA interim application that
In fact, some in my high court, no, not in my high court, in Patna High Court, the system of numbering of interlocutory applications is 1, 2, 3, 4.
like
So in every writ application or in every proceeding,
manner.
the first interlocutory application would be IA number 1.
IA number 1.
The second would be IA number 2, like that. So I put this question deliberately to know the.
No, that's correct. This procedure differs from High Court to High Court.
Right.
But your lordship is now the judge of this court.
Therefore, that practice in Patna High
This is
Court.
your lordship's court now. Let deeply oblige.
Okay. Come up on 4 weeks, Mr.
Smile,
And you are at liberty to file any application for vacating the order of stay.
smile. Oblige.
Item number 7.
May it please your lordship. Your lordship, I need few days time to file supplementary
All right,
affidavit.
how much?
Within the course of this week?
This week.
Yes, your
All right,
lordship.
1 week, 3 weeks.
My lord.
Item number 8.
And this petition arises out of a survey and settlement proceeding, my lord. Is a single judge assignment, my lord. Single bench assignment. Survey Settlement Act comes under the single judge assignment. Justice BP Raut is assignment. My lord.
It has been submitted by learned counsel appearing on behalf of the petitioner that as per this court's roster, the matter ought to have been placed before an honorable single judge. Stop. List this matter accordingly before appropriate bench as per the roster. So stop. You will have to file a supplementary affidavit.
No, that, my lord, your lordship may kindly bear with me. I will explain, my lord. Last 75 years, my lord, we have a format of affidavit, my lord. For last 75 years, and I have also spent here for 38 years, my lord. And your lordship has changed that. I asked question to myself, how it will help for my lord delivering the justice, my lord.
Because I cannot decide without the affidavit. We cannot.
And in a postcard, your lordship can entertain a writ application.
That is different. That postcard is different. If that is so, then why affidavit at all?
No, that is the
You
format
remove
for
that part.
my lord, that is for this format for 75 years, my lord. And we are adopting that. And your lordship is changing that affidavit.
We are not changing. We are
The
following.
format
We
is
are,
changing.
madam, don't say this. We are not. We are just following the rule framed by this High Court in 1948.
1948, my lord, that was not there, my lord.
So you are
It was
saying
changed. It has been changed recently, my lord.
recently.
Okay.
Very good.
It has been changed recently.
It is there since time immemorial. Without this, it cannot. We cannot proceed deciding writ petitions. Yes, we will see. You do whatever you want.
My lord, in light minutes,
As a young lawyer, I was appearing in Supreme Court and one counsel said that I have not seen it for 30 years. And the Honorable Court said you will now see.
So this is how, madam.
So every change, my lord, every change is always welcome.
We will see.
And this is not a change.
Yes,
This
yes.
is our own rules.
This is what. Yes. Madam, we are not doing anything new. All right. Yes.
Item 9.
Your lordship has, my lord, directed to list this matter on.
It will be listed. We cannot fix a date now. It will be listed.
Item 9.
Let's see, this matter, I may be allowed 1 week time to file.
1 week, 3 weeks.
Item number 10.
Yeah, please, your lordship. Your lordship, in this case, the summary order passed by the GST authority, which has been subsequently rejected by the first appellate authority, is under challenge before lordship since the appellate tribunal has not yet been constituted. So similar order has been passed by.
So those matters are coming up.
Your lordship, those matters, actually yesterday, those matters, 2 matters have been fixed, that those matters have been fixed and today, item 14 and 15. Your lordship, same, non-constitution of the tribunal. Your lordship, yesterday I have submitted your lordship's order. So it can be tagged with that and all these cases can be disposed of, your lordship.
Which is that? So have you seen that order?
Please.
So we will take up your matter with that, with item number
14 and 15.
14 and 15. In fact, I have forgotten the order which I had passed.
Your lordship, actually, I have gone through the entire order. Your lordship, it is equivalent to the order passed by this Honorable High Court. What happened? What is the difference between our order, our previous order, and your lordship's order?
No.
Is that?
The order of the High Court.
Your
High Court, yes.
Your lordship, Patna High Court. The difference is that in Odisha High Court, this Honorable Court has passed the order that you have, since you have deposited 10% at the time of filing of first appeal, you have to deposit 20% as per the section 112. And your lordship, this High Court has issued notice, admitted the petition, issued notice, and directed the department to file counter. Your lordship, what Honorable Patna High Court has said, Patna High Court has said the same thing. Since you have deposited 10%, you have to deposit 20%. On deposit of 20%, the remaining tax, remaining demand will be stayed. But Patna High Court, Honorable Patna High Court has disposed of the matter with a liberty to the petitioners that you have to file appeal, second appeal as per the statute.
Once the tribunal
is constituted. And if that appeal will not be filed, liberty has been granted to the department after the expiry of the limitation period to take corrective action. So the same order, only what happened, it is burdensome to us because your lordship wants, your lordship will direct to file counter. Once admitted and issue notice, we have to file counter. If we will not file counter, your lordship, then your lordship will ultimately. So it is burden to everybody, your lordship, burden to department, burden to petitioner, and burden to also Honorable Court, your lordship, pendency, because it will increase pendency. So after going through your lordship's order, your lordship, for that reason I am praying all these matters can be disposed of with a liberty. Because after the constitution of the tribunal, what will be happen? All these cases will be transferred. But your lordship, before the tribunal, the appeal will be in a different form. In grounds of appeal, statement of facts, everything your lordship.
That is the reason why
the
cases were disposed of.
Your lordship would kindly pardon me, my lords. If your lordship, I'm sorry, my lords, I have intervened, my lord, in this matter.
Please.
But the difference between the Patna High Court, my lord, is your lordships had referred to the Bihar notification, my lords. Your lordship may follow that order, but here your lordships have to follow the CBIC order, which is in same terms. It says, my lord, that 3 months or till the president or the state president takes over, whichever is later. That word later is also missing from the Patna High Court order, my lords. But your lordships have to follow the CBIC circular, my lords. And
So
another
circular has not been mentioned in that order.
no, that is the Bihar or state of Bihar.
No, whether the
CBIC circular has not been mentioned. Your lordship, the Patna High Court, Honorable Patna High Court relied on the Patna Bihar
Bihar notification.
notification. which is in consonance with the CBIC
Yeah.
notification.
Right.
But since Orissa does not have such a
The
notification,
Bihar notification is based on the.
CBIC notification, but it doesn't state so. It just states that the Bihar notification is an independent powers under the GST Act conferred to the states. Unfortunately, the state of Orissa does not have a similar notification, but a CBIC notification is still there, 2020 notification in similar lines.
So
And the
why-
language is
why-
also.
Why can't you also come out with such notification?
Your Lordship,
Your Lordship can pass because CBIC notification, my Lord, has a all pan-India application.
CBIC
So,
notification
so
is
your,
also valid.
instead of this Bihar state notification, your Lordship may refer to the CBIC notification. One other practical difficulty would be, my Lords, your Lordships have said that 20% of the remaining tax, if paid, the balance would be state till the constitution of the tribunal. Your Lordships, sorry, my Lords.
Please.
And your Lordship have to make a slight modification. What happens, my Lord, is the statute says 112 says 20% of the remaining tax. Unfortunately, when we go to the portal, unless we deposit this 20% while filing the second appeal, the portal does not take our second appeal. It will not take our second appeal. So your Lordship have to clarify that this particular 20% has to be considered by the authorities while the second appeal is filed when the tribunal is constituted. Otherwise, my Lord, that this particular difficulty would again arise when the filing of our second appeal is made, my Lords, because the system has not been managed in such a way where we can say that we have already deposited. So that will be in my very humble submission, Lord, two differences between the Honorable Partners High Court and whatever your Lordship proposed to pass on that.
Your Lordship, please, because all these what my Lord.
That 20% has to be clarified. Otherwise, again, my Lord, they have to come back to your Lordship's court asking for the system to adjust and enable them to file a second appeal, even though they have complied with the statutory requirements.
Can you give us short notes on this?
I'll definitely give it. Only two small differences where if your Lordship would incorporate it in our High Court's order, that would suffice and your Lordship may follow.
That will surely improve the situation.
Personally, I feel, I think my learned friends would also agree that these are the two main differences which has to be addressed by your Lordship's court.
Yes, to be reasonable.
Your Lordship.
So all these three matters will come on Thursday then?
Your Lordship. Your Lordship, also I have instructed to my office to prepare a list of all the cases pending where your Lordship has already issued notice and directed to pay the 20% of the balance amount your Lordship has directed, this Honorable Court has directed.
So what we intend to do is
your Lordship,
that to pass an order in three cases or four cases, which shall be followed in other cases.
Your Lordship.
So this is how we.
Your Lordship,
otherwise, all the cases will be required to be posted, and then
as an interim measure, whichever cases are now coming up, Lordship may protect them by asking them to pay.
No, we'll pass order on Thursday.
As your Lordship.
Thursday, you just give.
I'll give it.
Friday. All right. We are fixing these cases on Friday within first 5 cases, and by Thursday you give us the notes. On Friday we'll
just one small 2 paragraphs, to be incorporated.
We'll do that. And he's also not objecting to it.
No, I think my learned friend would agree, subject.
Your Lordship, I am agree with my learned senior, but it is only anticipation. So far as whether the tribunal will.
That is a practical difficulty, my Lord. That's a practical difficulty.
Your Lordship can direct, Your Lordship.
I'm sorry.
Your Lordship, item number 10, 14, 15, 16, 17, 18. These all matters, and also item 21.
On Friday to be taken up.
Let's say 10
at the top of the list.
Item 10, 14, 15, 16, 17, 18, 21 of today's list. Get fully.
I got 16, 17, 18 additional affidavit to file, supplementary affidavit. 16, 17, 18, supplementary affidavit will file by Thursday.
Your Lordship, that affidavit, all the cases, in all the cases,
since we are disposing of these matters in you have admitted facts.
Get fully.
Greatly obliged.
Item number 11.
Was 11, my opinion. Filing supplementary affidavit also. Here, my lords, annexure 11 is under challenge. The order of the collector,
Which page?
page 51, my lords, annexure 11, wherein though the collector has considered the representation of the petitioner that was filed pursuant to the direction of this honorable court, but my lords has not come into a definite conclusion or a finding. My lord, the case is that, my lord, the petitioner's mother, my lords, 2 OS shops were registered in the name of the petitioner's mother, my lords.
Yes.
My lord, the 2 OS shops, Balipadar and Janibali, were registered earlier in the name of the petitioner's mother.
What is OS?
Outstill liquor shop, my lord. Until 2012, my lord, on 11/12/2012, the petitioner's mother.
OS, what is OS?
Outstill, my lord, outstill liquor shop. Outstill, my lord.
Outstill.
My lord.
Spelling?
My lord,
Outstill.
OS liquor shop.
What is the second word?
Still, my lord, STILL, double L. My lord.
Non-mobile. Still means what?
My lord.
Out still means
Country, my lord, country liquor.
still.
Lord, may I clarify?
Outstilled
May
what?
may I assist, my lord?
Still, my lord, is a
There are-
container.
There are
Where it is fermented, it's country liquor.
country liquor.
Outstill
There-
liquor is country liquor.
There are 3 types of liquors in Orissa, my lord. One is outstill, they call it OS. That is, my lord, made of the mahua flower. That is, my lord, applicable in 21 districts of Orissa out of 30. The other, that is a country liquor. And the other one is country spirit, CES. My lord, that is more made of this molasses. My lord, commonly they call it Aska 40. It was earlier called. That's a country liquor. The third category is the rich man's liquor, IMFL, Indian made foreign liquor. So that in Orissa, they have gone for auction in IMFL and CES.
In the state of Odisha.
That's correct. CES,
Which is most common? OS,
that
CS, or
common is
IMFL?
this OS and CS. OS OS distillery, that 350 crore cash which was recovered, that is the OS manufacturer.
Thank you. Yes.
My lord, so my lord, these OS shops were registered in the name of the petitioner's mother. While the petitioner's mother died on 11/12/2012, Lord, OP 5, 6, and 7, the brothers and sisters of the petitioner, what they did is that during such period, petitioner suffered from serious ill health. Taking advantage of that, the siblings, all the brothers and sisters, more particularly OP 5, by forging documents and forced partition deed as well as consent.
Inter-party dispute.
No, ma'am. What happened is that obtain the license, my lords, in their favor, in favor of OP 5, taking advantage of that situation. While the petitioner came to know, he made a complaint to the collector, my lords, to make an inquiry into the same and to grant the license in his favor, for the reason that he is the eldest son, my lord.
The collector has held.
My lord, what he did is that, though he has ascertained regarding the ambiguities, if a lordship may see the operating part of the order, page 52. Thus, the matter being civil in nature in view of the time constraint, though it is ascertained that Sri Sibanaran Patnaik, who is the petitioner in this case, happens to be the eldest of the legal heirs of his deceased mother, as almost 10 years have elapsed in the meanwhile, considering the material evidences available on record and the ambiguities involved, especially in the deed of partition and affidavits of consent, which need further verification at appropriate level, it would not be expedient to come to a conclusion on the allegations raised by the petitioner at this stage. Hence, it may be preferable for the petitioner to go for civil suit. My lord, direct the petitioner to go for civil suit while asserting the fact that the OP5 has, by forged documents, has got the license.
You don't file if you don't want.
My lord,
He is not compelling you to file a suit.
my lord, petitioner is put to suffer, my lords, because
No,
of
no,
this.
sorry.
My lord, he is the
These matters
eldest son,
should
it
not
has
happen.
been ascertained.
Sorry.
My lord, he is the eldest son, and as per the law, my lords, as per Rule 43, the eldest son is to be granted the license. My lord, it has been proved by this order, everything observed that.
This is the law
My lord,
that the eldest son should be granted license.
my lord,
Bring that law, we will hold that law to be unconstitutional.
my lord, rule is there, my lord, sir.
Sir,
Odisha excise rules is
kind
there.
of the eldest
Rule
son.
43, my lord.
Yes, sorry.
Rule 43, it is there.
Okay.
Only I pray, my lord, since the illegality has been pointed out by the collector, now
Sorry, sir.
OP5 cannot be allowed to continue
Sorry.
running the license, my lord.
Sorry. The petitioner has put to challenge an order dated to challenge in the current.
Then, my lords, may I pray, my lords, the petitioner may approach the appropriate authority.
No, sorry.
My lords,
We are making it clear. We will not enter into normally, in exceptional circumstance, yes. This representation business.
Not
We
representation.
shall either allow, just a minute. We shall either allow your writ petition or dismiss your writ petition or adjudicate upon the disputes. But we will not just for the convenience of we will ask you to file representation and take a chance there.
Only he will approach this civil suit, my
Why
lords.
he has decided.
Withdraw, my lords, with liberty.
Withdraw, you may withdraw.
Also may observe.
Petitioner, after some argument, seeks permission to withdraw this writ application with a liberty to approach appropriate forum for adjudication of the dispute. Stop. This writ application stands disposed of with the liberty as sought for.
Item 12.
Item 12. Lordship, since I'm challenging a minimum eligibility criteria set forth by the tendering authority, this honorable court had put a question to me as to whether this court has jurisdiction to interfere with the terms and conditions of the contract or the decision making process of the contract or not. I've done my homework and I'm placing my memo of citation. And these decision, the Honorable Apex Court has held that terms of an invitation of tender are not open to judicial scrutiny since they are in the realm of contract unless they are arbitrary, discriminatory, tailor-made or actuated by malice to benefit a particular tenderer or a class of tenderer. Now, the minimum eligibility criteria that I'm challenging, I am to demonstrate your lordships as to how this is discriminatory and as to how it is supporting and it is tailor-made for a specific class of contractors. Lordship, may kindly have a glance at page 23 of my writ petition, where the minimum eligibility criteria has been mentioned. Page number 23. The registered, I may be permitted to place it.
Yes, please.
The registered contractors should have successfully completed RCC drain, RCC culvert, RCC bridge work of a single agreement amount not less than 40% of the amount put to tender in any one financial year as per the table below. Now, my contention is that this completing similar nature of work amounts to having an experience. I have no issues with that. But the fact that the agreement amount not less than 40% of the amount put to tender. This means that only moneyed registered contractors are allowed to participate in the tendering.
That is quite reasonable.
Lordship,
the employer has also to see that the contractor has the potential to execute.
Yes. There is a decision also.
If someone who does not have money to execute a work, then how can he do that? And therefore this condition. And this condition is there in almost all the tender notices.
Tender notices. Another one thing that I will place, that this classification of contractors is already there in PWD contractors registration rules under Rule 3. Under Rule 3, there are 6 categories of contractors. This further classification, this sub-classification is what I have my contentions with. I'm agreed. So sub-classification amounts to overriding of the rules, 1967 rules. So if an A-class contractor, I being an A-class contractor, I'm participating in the tender process, but I'm being not being declared not eligible due to this minimum eligibility criteria. So this sub-classification is overriding.
All.
the-
That's all.
Yes.
Yeah. Third and counsel for the petitioner. And run counsel representing the estate. This matter for judgment on 4 weeks. We are sitting. Judgment on 4 weeks. एक और judgment है. Yes, 12. Thank you. And we are very happy.
Item 13. May I please, my lord, in this case, the petitioners have challenged the order dated 36/2023 by the Annexure 1 running page 13 passed by the Learned Collector just.
Which annexure?
Annexure 1, my lord, running page 13.
Yes.
Here, one tender was called for construction of sub-center of health department as per National Health Mission scheme in the area of Bayanghi Panchayat of district of Bhadrak. My lord, kindly have a glance to running page 14. Conditions in that order also mentioned the site para 2, my lord. I will place, my lord.
So what is the dispute about?
Dispute is that National Health Mission floated a scheme that health sub-center will be constructed. Health sub-center will be constructed in different panchayats of the state. And as per that, the advertisement was floated and by the annexure, my lord, running page 18, annexure 2 series, or serial number 13, Bang DSC, Mouja Bang D, Khata number so and so and so.
Who are you?
We are the villagers of Bayangdi.
Villagers of?
Bayangdi Panchayat. Bayangdi village and Bayangdi Panchayat.
So what do you want?
We want the sub-center should be constructed on the spot for which tender was called for and tender sanctioned, but without constructing the building on that spot, they are trying to construct in another spot which is beyond the guideline as per their order also. Running page 14 subclause 3 second para, the site shall not be close to minimum 3 kilometers of existing SC, PSC, and CSC.
Where is that? Which? Where?
That is running page 14, my lord. Para 2.
Page 14.
My lord. Para 2, third clause is there.
The site shall not be close to minimum 3 kilometers.
My lord. Then, my lord, may kindly have a glance to running page 34. I have obtained that document under RTI Act by Annexure 3 series.
No, but what is the order?
Order is that they have cancelled my the construction of the site at Boyangdi, but they have trying to construct at another Mouja, that is Shivpur, which is near 1.6 kilometer to different medicals.
You must have taken this point before the collector.
Yes, we have taken that, but
So
illegal
how has it
earlier,
been
as per the Honorable High Court's order, the Honorable High Court, my lord, may kindly have a glance to last para, page 15, my lord.
So
Last but 4 lines of that page 15. Last but 4 lines.
we have seen. Yes, the logic which has been given cannot be interpreted.
No, my lord. I am clarifying that. My lord may kindly have a glance to running page 34.
Mr. Counsel, the scheme which you are showing,
My lord.
no PHC and Balaso and sub-center exists within 3 kilometers.
My lord.
This does not have any statutory force, which is of binding character. So that is simply guideline.
My lord, the guideline, they have violated their guideline.
They may violate. They may violate unless that the guideline is held to be mandatory. We can say that this is not mandatory.
My lord, may kindly have a glance to my lord's order, that is 8/1/2024. Earlier order was that Learned Government Council was directed to obtain instruction regarding the distance between the existing health center situated at Mauja, Bangdi and Shibpur. Let them to give that instruction. Actually, in para 4.
Mr. What is the distance between the previous site and the present site?
That was the direction to Learned Government.
You please tell us, what is the distance between the previous site and the present site?
My instruction is more than 4 kilometers. That for my instruction.
Present site and the previous site. All right.
So far the further problem is that So for my previous site was that is Bangdi, that constitute of 9 wards. More than 4,000 people live there. For the last, in the proposed site in which they are trying to construct, there is only 456.
Please try to understand, these are administrative decisions. We sitting here cannot decide as to which site is should be more preferable than the other one.
As per their guidelines and also.
As per their guidelines, they are also democratically elected people. They know the public interest as much as we know.
My lord, that was the advertisement also, that such criteria should be there for the establishment of a sub-center. With the violating the criteria of the advertisement, they are trying to construct. That is that is the grievance of the petitioners before me, lord.
Then you can you satisfy us that this guideline is mandatory.
May I pray one thing, my lord?
Yes.
Let it come day after tomorrow so that I can satisfy.
What can you satisfy? As requested on behalf of we are not satisfied. This matter on Thursday.
Then may I place the para 4 of the running page 14, my lord?
Yes.
Subsequently, BDO Dhamnagar along with team of AE Dhamnagar, AE, NMH, BFM and RI have visited to the said site.
Mr. Please try to understand. We do not have the wherewithal to conclude that this is the site where a PHC or a hospital or school or any educational institution should be established.
Yeah.
So the final decision will have to be taken by them. And they have taken a conscious decision that pursuant to this court's order, they have considered your representation. They have rejected it. And they have recorded that this site is better than the previous one. About the previous one, they say that it is not possible to have a PHC over there. This is specific.
My humble submission before my lord is that whatever ground they have stated, that is not correct as per their information provided under RTI Act. The ground on which they have rejected our prayer.
So you are relying on the information given by the
authority, my lord, their authority.
So the RTI people will rule the decision making.
No, RTI, that is the RI who has investigated.
All right, we will decide. We will settle the issue, such issues. All right. By a judgment. The scope of this is PIL or what?
Yes, PIL.
Yes, we will decide the scope of PIL.
Yeah.
PILs in such matters.
Right.
Current counsel appearing on behalf of the petitioner seeks short adjournment to satisfy this court on the point of the mandatory character of the guidelines issued by
National
Health Mission.
Mission. Annexure. Which annexure? You have not annexed the entire scheme. You have just annexed part of it. And the scope of this court's interference in a proceeding in the nature of public interest litigation for selection of sites for primary health center.
Sub-center. It's called sub-center.
Primary health sub-center. All right. as requested, list this matter on Monday, next Monday.
Item number 19.
Mr. Counsel, please file your affidavit in the meanwhile. Affidavit.
Supplementary affidavit. Well. Yeah, I did find that, yeah.
Yes,
May please your lordship.
which item number 12?
19.
Item number
19.
19, Milord. That this matter, in fact, involves a very larger public interest, Milord, wherein the apathy and indolence of the state government is under challenge for non-implementation of the Ayushman Bharat Yojana, Milord, which is the largest healthcare incentive in the country, covering around 50 crores of people and 10 crores of families in the country to have access to the healthcare system all over the country, including private, government, and other hospitals, numbering 28,000 hospitals all over the country to the extent of out-of-pocket money 5 lakhs of rupees. 3 states, out of 33 states and 8 union territories in the country, they have not adopted. Kerala, Delhi, West Bengal, and Odisha. Rest of the 30 states, even the richest states of the country like Punjab, Rajasthan, Kerala, Tamil Nadu, every state has adopted along with their own state scheme. They have their state scheme as well as this national health insurance scheme, which some states have 5 lakhs, they have some about 5 lakhs. In addition to these 5 lakhs, suppose a critical patient is admitted in an outside state hospital, he can't have access. Orissa has a health scheme of its own. They cover only 98 hospitals all over the country, whereas this Pradhan Mantri Jan Arogya Yojana covers 28,000 hospitals all over the country, covering cancer, cardiac arrest, everything, all critical illness. 2017-18, if your lordship recollects, while presenting the national budget, the finance minister announced the scheme under the National Health Policy, Milord, which is basically not from Article 47 of the Constitution, though, Milord, contained in Part 4, but most of the articles, Milord, engrafted in that part, Milord, by flux of time have been given.
So your simple submission
Milord, in addition to this, yes,
that this Pradhan Mantri Jan Arogya
Yojana
should be implemented
maintained
here
in the
also in the
state of Orissa. Milord, we are not opposed to the state scheme. Let it continue. Along with, Milord, there is no bar for implementation of this national health scheme, Milord, which would be beneficial of the poor people of the state. Migrant laborers are not covered. There are around, Milord, 15 lakh migrant laborers, those who are working in far off places like Surat. That is the major chunk of the Odisha migrant laborers, Milord. They go to Chennai, Karnataka, Bengal, everywhere, Milord.
Is there any requirement for the state to take a decision for implementation?
That's correct, Milord. There are, Milord, only 3 states. I do not know what is the compulsion.
Is there any requirement in the scheme that for its implementation, the
The
state
state is to, yes. The state is to
take a
concern.
decision?
Yes, Milord. The state is concerned. They have to sign an agreement with the central government because
Where
the
is that required?
Milord, your lordship would come out from the scheme. Milord, your lordship may kindly turn to Annexure 2 is the scheme. So, where is that? No, that is apart. Milord, 3 models I have annexed: Kerala, Rajasthan, and Karnataka.
Forget model. Where is the?
Milord, this scheme is at page 36, your lordship would find. Milord, the state's consent is necessary because this is basically in the state list, public health and sanitation.
No,
Milord,
where is the?
Milord, that is under the one minute. Milord, let me just. Milord, may I just find out? Milord, Milord, there is an agreement to be signed with the national. 1 minute, Milord. Let me just find out. Payment of central share, Milord, pays 50, Milord.
Page 50.
Page 50. Mixed model, page 48. Yes. Under this, it's a mixed model method. SHA, Milord, this state health agency is SHA. And NHA is the national health. Page 48, that is the objective of this scheme. Both the assurance, trust, and insurance models mentioned above in the various capacities with the aim of being more economic, efficient, providing flexibility, and allowing convergence with the state scheme. This model is usually employed. Milord, okay, where is it?
No, next page is not there.
Is completely funded by government, Milord, is shared between central and state governments. Milord, page 50, Milord. And the costs are shared between central and state governments. Page 50, Milord, I am reading. The government of India decides a national ceiling amount per family that is used to determine the maximum limit of the central share of the contribution. The actual premium discovered through open tendering process at the maximum ceiling of the estimated premium decided by the government of India for the implementation of Pradhan Mantri Jan Arogya Yojana, whichever is less, would be shared between central government and states, union territories in the ratio as per the extant directives issued by the Ministry of Finance from time to time. In addition, administrative so and so. Milord, there is a state share admitted in this. So, Lord, what I objectively pray and submit to Lord Sahib's judicial conscience that apart from the state scheme, Lord, all the states in the country except 3, West Bengal, Odisha, and Delhi, they are averse to this national health insurance scheme, which would provide larger coverage. And that is a concomitant of Article 21 also, right to have easy access to the healthcare system all over the country. But that is a basic philosophy,
No, but
which
please
is
come to page 50.
Page 50, Milord. The existing sharing pattern is ratio 60-40, Milord.
No,
The para 2.
PMJ is completely funded by the government.
By the government, Milord, under the insurance scheme. The entire 60,000 crore they made provision in the budget, Milord, to be borne towards the expenses.
JY is completely funded by the governments.
By the governments.
Not government.
No, governments. Both, Milord, center and state.
60-40
60-40 ratio. But it's for the protection of health and nutrition of the larger, it's the biggest healthcare incentive in the world.
Do you have any instruction?
50 crores of people.
Lord, your Lordship may see there is a rule 8 under our PIL rules.
Under PIL.
My Lord, if my Lords kindly turns to page 188 of that book. We have Odisha High Court Public Interest Litigation Rules 2010.
Yes.
And Rule 8, my Lord, says that before filing a PIL, the petitioner must send a representation to the authorities concerned for taking remedial action akin to what is postulated in section 80 CPC.
Just.
I'm sorry. I'm so sorry.
188.
Should be page 188. Because there's a different book.
Page. We can find out.
Yes, yes. Should be page 188 if your Lordships are holding up this book. Rule 8, Milord.
Yes.
Before filing a PIL, the petitioner must send a representation to the authorities concerned for taking remedial action.
So there was no representation.
There is no representation.
I'll explain.
Just
let him finish. I'll
So,
explain.
Milord, the reason why I'm asking for this is, apart from this rule being mandatory, and what he is seeking implementation is something which happened in 2018. So we are now in 2024. 164 hospitals across different states, including Surat, which my learned friends was talking about. They have a tie-up with the state government under our schemes. So it is not to say, Milords, that our scheme does not extend to places outside Odisha.
All right.
So that is one. Second, our scheme is far superior in the sense, my Lord. Every lady who is covered under the scheme gets 10 lakhs free medical coverage annually. and every male gets 5 lakh coverage annually, while the central scheme has a 5 lakh per family subject to correction by my friend. So therefore, this scheme is more beneficial, and it also addresses the people of Orissa who are working in different parts, and as many as 164 hospitals across the country have already been empaneled, including Surat, Calcutta, Visakhapatnam, etc., etc.
Lord, I am explaining. No, Lord, I am not opposed to the state scheme. Perhaps my Lord, rule 8. No, let
You
me
are saying
explain
that
one by one.
It should be in addition to, that is one thing.
Now,
But
I am
he has-
explaining rule 8, Milord.
Right.
I am reading rule 8. Your Lordship may kindly read with me. Lord, before filing, your Lordship may kindly turn to the last, however, the last, Lord, that is a part of that rule. However, in urgent cases where making of a representation and waiting for response would cause irreparable injury or damage, petition can be filed straightway by giving prior notice, which I have already given to the state of filing to the authorities concerned and or their counsel. Milord, your Lordship may kindly turn to para 5 of the format. Milord, para 6. The next rule, Milord, para 6 of the PIL format. That the petitioner has not sent representation in this regard. If yes, details of such representation, reply if any, from the authority concerned along with copies thereof must be filed. If not, the reason for not sending such representation, which I have explained, that the Government of India, Health Minister of the Government of India, he has written to the state government. You will also put find at page. It's not a question of making a representation when it concerns the health hazards of the people. 164 and 2000, 28,000 hospitals. Hell and heaven difference.
Mr. Advocate General has rightly pointed out
My Lord.
that the matter is not so urgent. That
The matter,
you should
my Lord,
have-
since
that
18
you
they are
should
not
have-
implemented.
That you should have approached the High Court without even approaching the concerned department or the government.
No, Milord, the Government of India has already approached them. I am an individual, Milord, espousing the cause of the people.
So therefore, you should have approached with the communication.
No,
which has
that
been issued by the
explanation I have given in para 6 of the writ petition. You will also kindly tell. Milord, because the central government, they are not responding to the Milord minister's letter of the
We
central
will
government.
not enter.
Milord, no, that's correct. So, Milord, it is a question of the benefit which is being extended to the people of a state. It's a larger public interest, Milord. A representation is a mere formality.
No,
It is not
a formality. It's not a mere formality. Instead of entering into the dispute which you are raising and which he is raising in the present petition,
My Lord.
they could have informed you. They could have taken a decision that, see, this is the reason why we don't want to implement, or we want to implement. They may accede to the your request. They may decline to accede to your request.
No, Milord, my request, Your Honor, I am an ordinary citizen. I am, Milord, a public man. This
You are not an
government
ordinary
of India, Milord.
You are not
No.
an ordinary citizen.
No, Milord, the government of India, they have been requesting the state government since 2018 for implementation of the scheme through various communications, including the health minister's
So
letter,
therefore,
which I have annexed.
Mr. Health Minister's letter is not something which we are bound by.
No, your lordship is not. I'm just, Milord,
Therefore,
justifying
if
that the
there
government
if there is some communication by the health ministry to the state government, and according to you, the petitioner who has approached to you, a senior counsel like you, then you could have approached the department also to convince them that, see, our scheme is better. You give this scheme also in addition to what you are providing. They might have convinced you that, see, my scheme is better. We are not required to implement this scheme. So, and since when your scheme is there?
Same year,
15th
2018.
of August 2018.
2018. All right.
15th of August 2018 is the state scheme. September 28 is the Government of India scheme. That they made special provision in the budget, in the annual budget of 18-19, in the parliament itself, and requested all the state governments all over the country, Milord. Every state government acceded to it, including the state of West Bengal. Even Milord, for different reasons altogether.
Whether
Odisha-
the state of West Bengal had the kind of scheme which the state of
But
Odisha
every
is having.
state has the state scheme. Rajasthan, Milord, for example, Rajasthan is providing 20 lakhs, Milord.
Maybe, but
Here,
still, we are
State under the
convinced-
state scheme, Milord. I have given the
Mr. Acharya, we are are convinced with this submission with reference to Rule 8 of the High Court rules that you should have approached the government first before coming to this court. It's not so urgent that it should be taken up without.
Milord, when it concerns the health of the people, Milord, nothing is more urgent than the health hazards of a citizen. Milord, why I am submitting, Milord, this representation.
Tomorrow you come to this court with case of a person who is suffering from a serious disease and not getting sufficient assistance for financial assistance or anything. We will take up such matter without any affidavit, without any requirement of this Rule 8, and we will pass necessary orders. But not in this matter. You are saying that this is so urgent that we should proceed.
Why it is urgent, Milord? Let me just explain, Milord. I know now the Rule 8, Milord. The basic object of that Rule 8 was to avoid frivolous petitions, Milord, because lots of PIL, so-called.
No,
It is not
Acharya,
a petition, Milord.
Mr. Acharya, sorry, that is not the purpose of Rule 8. The fundamental principle of seeking a rule or in the writ in the nature of mandamus is that you must make a demand first. Then only a command can be issued. If your demand is
right.
declined.
I'm not disputing that proposition, Milord, but in a PIL, your Lordship knows that even on the basis of the newspaper reports, your Lordship takes cognizance.
We can take up in, yes.
So that's correct.
In
Milord,
appropriate
here is a
cases.
case actually. Milord, since 2018, there has been innumerable demand by the people, by the civil society, by the political
Then why did
parties.
you come in 2020?
So, Milord, we were expecting that good sense will prevail in the state.
2021.
No, Milord, I'm explaining.
Mr.
Milord, every democratic
2022.
government, Milord, your Lordship, we were expecting that some good sense will
Therefore,
prevail.
expect.
And the state government will implement the scheme with all fairness.
All right.
Milord, they have other reasons. We are not on that, but we are on the question of a larger public importance.
We will
Milord,
see that.
for
Once they
implementation
decline,
of the national policy.
Once they decline your request, you may come to the court to tell that they have declined, they have given reasons which are not valid, which are illogical. We will see.
So, Milord,
Otherwise, see-
Milord, your Lordship, that is correct, Milord, but your para 6, I have given the explanation. Your Lordship, kindly.
We will deal with that.
I have para 6, Milord, we have clearly stated that there are innumerable communications between the center and the state.
Yes.
That is a basic requirement of to respect the federal structure.
Sorry, Mr.
That is what, Milord, your Lordship, in that event, what I pray, Milord, your Lordship may give in liberty now, I will, Milord, let it lie over. In the meantime, I will make a representation and come back. Your Lordship, let it lie over, because, Milord, once let it lie over.
Why?
In the meantime, Milord, what I am praying, that is, Milord, what I am praying, Milord, it is certainly, Milord, involves the interest of crores of people. So, Milord, in addition to 5 lakh, if they get an additional amount of 5 lakh to take care of a critical health situation, Milord, confronted with any person.
Senior counsel, why should we presume that the government is so insensitive that it will not be ready to consider welfare schemes?
So that is
Any
exactly
government
what
for
is
that matter.
hunting, Milord, everyone. That
Unless
is exactly.
unless it is shown to the court that the state has proceeded against any statutory requirements, a different matter. But here it's a policy matter.
That's correct.
The courts would normally presume that the governments are sensitive, that the governments are conscious of the situation.
Let's see,
The
is
governments are
absolutely correct.
independent
A
to decide.
government, Milord, a
Of course,
welfare
therefore-
government. Your Lordship, kindly then in that event, what I pray to your Lordship's judicial conscience, let it lie over. In the meantime, let me represent to the government and come back with the response. So, Milord, 5 years, your Lordship knows is good enough a period. If the government's apathy and sitting over the scheme for last 5 years,
Yes.
6 years almost, Milord,
Yes.
that is good enough to justify that the state is averse.
Yes.
The state is not keen to implement. That is good enough to deduce. Your lordship can take judicial notice of that. If a government is not non-responsive
Yes.
and doesn't,
Yes, we
Milord,
will come back within 5 minutes to write the order.
so your lordship may say that in the meantime, let it, Milord, I pray, lie over. Milord, it's not a petition
will
which
not-
could be thrown out outrightly, but your lordship
Yes,
may keep it.
we are going to dismiss this writ petition as not maintainable. That's all.
Milord, dismissal would be in that event, I may be permitted to take back, withdraw, and I will come back.
No, it is better if your writ application is dismissed as not maintainable. We will give you liberty to approach and to come to the court again after fulfilling the requirement of Rule 8. All right?
Your lordship may say so. Not dismissal is a word, Milord,
No,
which haunts
dismissal is a
the...
very good word.
I can
Dismissal
appreciate.
is as
So
good as
your lordship may say that since
allowed.
Rule 8 is to be complied with, it is disposed of with this, that way. Had it been, Milord, some other issue, I would have personally, Milord, submitted that it's...
This writ petition under Article 226 of the Constitution of India has been filed in the nature of public interest litigation seeking direction to the state government of Odisha to implement Pradhan Mantri Jan Arogya Yojana, bracketed PMJAY in short, which is said to be a national health and assurance scheme under the flagship program of the government of India, namely, quote unquote, Ayushman Bharat. Stop. Learned Advocate General representing the state of Odisha has taken a preliminary objection with reference to Rule 8 of Odisha High Court Public Interest Litigation Rules 2010, framed in exercise of the powers conferred under Article 225 of the Constitution of India, and in the light of the direction issued in the judgment in the Supreme Court's decision in case of State of Uttaranchal versus Balwant Singh Chaufal and others reported in. Do you have SCC equivalent?
Yes,
reported
Milord,
in.
We will furnish it.
2010 volume 1 OLR SC 380. Equivalent citation.
This is your line. State of Uttaranchal.
Rule 8 of the aforesaid rules reads as under. Stop. With reference to the said rule, Learned Advocate General has submitted that the petitioner has opposed this court directly without complying with the requirement of rule of the said rule. Without complying with the requirement under the said rule. Stop. Next, Mr. Acharya and senior counsel representing the petitioner in response to the preliminary objection taken on behalf of the state has submitted that as the matter relates to the health of huge population of the state and
Therefore, an element of urgency being attached to it, comma, the writ petition should be entertained by this court, taking into account the petitioner's explanation mentioned in paragraph
6.
Paragraph 6 of the writ application. Sentence correction. Sentence what? Stop me. Taking into account. Stop me. We have carefully perused the pleadings on record, and we have considered the rival submissions advanced on behalf of the parties as noted above, with reference to the maintainability of this public interest litigation, with reference to Rule 8 of the rules for topic. We are satisfied that the relief is the petitioner is seeking in the present public interest litigation is not of such urgent nature that requires the court to maintain the writ application even without complying with the requirement of approaching the state in accordance with Rule 8 of the rules. Stop. In our considered opinion, this writ application, comma, in its present form, comma, cannot be maintained. Stop. Maintained and is accordingly dismissed. Stop. Next. It is, however, observed that it goes without saying that the petitioner shall be at liberty to approach appropriate authority under the state government of Odisha by way of a representation or otherwise by way of a representation. Stop. The petitioner shall also be at liberty to approach this court again after complying with the requirement under Rule 8 of the rules.
You wanted the equivalence of the citations.
Yes,
Sir, that is 2010 3 SCC 40.
No, I've given it. AR and SS both have given.
Thank you.
OP number 3 and 5, the union opinion only.
Please give us words. Thank you.
Item number 20. Made pleasure lordship. Petitioner challenges the construction of A&M sub-center on a gochar land of another village other than the village where the tender has been finalized.
This is the same case your lordship has had and kept it for judgment. That sub-center from one place to another place.
It is on the gochar land. Already in that village, there is a public health center, the Ayurvedic hospital there. And there's constructing there, adjacent to that hospital. Already from 1990, A&M center has been sanctioned and functioning in village Badarampe.
You are resident of which village? You are resident of which village?
Village where the tender has been finalized, that is Border Rampe.
All right.
Border Rampe.
Just a minute. So you are resident of village?
Border Rampe.
Border.
BADA.
BADA.
RA. MPEI.
MPEI. Border Rampe.
Border Rampe.
All right. So
they are constructing at Bhotka on a gochar land.
Bhotka. They are constructing.
Just started construction. Then Bhotka.
Yes.
On a gochar land. Tender has been finalized here. Lordship, kindly see page 14.
So tender is in whose favor? The work was awarded in whose favor?
In favor of Border Rampe. In favor of opposite party number 6.
Opposite party number 6. So whether opposite party number 6 is instrumental in filing the present writ application? Is he interested? He appears to be interested person.
No. He is not interested. I am the villager. Because they have violated.
He has approached this court through you. You might not be knowing.
Pardon, I don't hear.
The contractor appears to have approached this court through you, your client.
No. We want tender has been finalized in favor of our village.
Therefore, your submission is that the contract should be awarded to the successful bidder.
Yes.
This is your submission. This is what you want.
No.
Then?
I want the construction should start on the village.
Yes.
Where tender has been finalized. And there is a sub-center functioning since 1990. Sub-center functioning. The building there was in a dilapidated condition.
All right.
Tender was.
About it. Which date we have fixed that?
That is
19th.
on Monday.
On 19th.
Fixed return Monday.
19th of May.
I don't
number 13 of today.
I am not remaining on because I am going to Sabasti. I will come on 29th.
All right, 29th. That matter is coming on 19th.
The status quo.
This 19th.
This
status quo, there is no question of status quo.
Milord, they will start.
Let them complete it. Let them complete. If we find that construction is illegal, we will direct them to demolish.
Yes.
We will direct them to construct at the place where you want that to be there.
Border Rampe.
We don't know.
There is already existing A&M center. Tender finalized in favor of a Border Rampe because the building there was in dilapidated condition. They are starting construction on a gochar land.
See, we are not the health secretaries. We are not heading the revenue department or the panchayats.
Already A&M center is there at Border Rampe. It is because that building was in a dilapidated condition.
Where is this new health center being constructed?
They are constructing Bhotka, the village of MLA, local MLA.
So have you implemented Bhotka people as party?
Correct.
Bhotka people, they have been implemented as party. All the villagers.
Is it possible?
If it is not possible, then how relief can be granted in your favor without hearing them? They are the beneficiaries.
They are the beneficiary. See, Lordship, how?
We will decide.
My lord is keeping it to 29th.
Yes, whenever he wants. This matter will come after that judgment comes.
Yes.
So once that judgment comes, then it will be easier for us to decide other matters. All right.
29th. Is it fixed to 29th or March?
Whenever 29th February, you are coming back on 29th.
Week commencing 4th March. That is because 29th is the.
All right. 4th. As requested on behalf of the petitioner, list this Matter on 4th.
Item 21.
20, your lordship, 21 is similar to
Sorry.
that matter.
Item 22.
22, my lord, I prefer next week to file fresh affidavit.
Fresh application.
Fresh affidavit.
Sorry, supplementary. 1 week, 2 weeks. Is the matter urgent? Whether the matter is urgent?
No, not
4 weeks.
similar matter, identical matter, item 75.
What happened? Acha. All right, we'll see.
Item 23.
May I please, your lordship? Your lordship, in this matter, your lordship, I'm challenging, your lordship, affidavit within 2 days, I undertake to file within 2 days. Your lordship, only my prayer, limited grievance is that here I have challenged the inaction of the opposite parties, your lordship, for the refund has been determined, your lordship, on 28 February 2023.
Which item is this?
23.
23.
Your lordship. Your lordship, here, the refund has been determined on 28 February 2023, your lordship. And from 28 February 2023, from post to pillar, I have approached, but till date, that refund has not been credited. Your lordship, the fact of the case is that initially in the assessment, there was a demand.
No, but let it come in the next week. In the meanwhile, you file your affidavit.
Your lordship, by Friday, I will file, your lordship.
Do it.
Only I pray
Monday.
let a direction be made to the department to take instructions. Your lordship, please.
Monday.
Your lordship.
Post matter on Monday. As requested on behalf of the petitioner. So as to requested by learned counsel appearing on behalf of the petitioner so as to enable him to file a supplementary affidavit in support of the averments met in the writ petition. Yes.
Get
24.
May I please, my lords. So this is a matter that the petition has challenged, my lords, an order passed by the proper officer, my lords, purportedly under section 130, subsection 1, and also 122 of the GST Act, my lords. Of Miller's payment of fine. That's it said that you pay fine and penalty in lieu of confiscation and get release of the goods, Millers. The lordship will see, kindly see, Millers, annexure 1.
We are insisting on filing of proper affidavit.
I think in this case we have filed, Millers.
You have filed.
Minors. Because it's filed only very recently. Yes, I have read it. Yes. Millers, my lords may kindly turn to the show cause notice, right? Annexure 1 at page 24, Millers. My lords will find this GST DRC 1 at page 24, Millers, show cause notice. The section at serial number 4, section subsection under which SCR is being issued is section 122, Millers. This 122, Millers, is a provision which seeks to impose penalty, Millers. 122. And below that, Millers, table, my lords will find followed by another table in which there is mention of grounds. Your lordship will kindly see serial number B, grounds. And one of the grounds is contravention of section 130B, Millers. 131. That provision, Millers, provides for, Millers, confiscation of goods, Millers. And it gives...
Which ground?
Grounds, Millers, my lords will find the same page.
There are 4 grounds.
There are 4 grounds. But nothing is... there are 1, 2, 3, 4. There is no specific, because 131 provides for 5 reasons that may entail penalty, Millers. But no specific reason is pointed out, Millers. My humble submission for RCP is, Millers, penalty is a distinct proceeding, so also, Millers, 131. The language used in 131 also refers to imposition of penalty under 122, but 122 itself is an independent provision seeking to levy penalty, Millers. But 131 cannot be understood to be a provision for imposition of penalty. It speaks of confiscation of goods. It's a consequence, Millers. But my humble submission is, if your lordship will see, Millers, for the impugned order, Millers, that is page 66. It starts from page 66, Millers. Annexure 4. Page 66. My lords may kindly turn to, my lords. Page 67, for the sake of convenience, the provision, order imposing penalty under section 122 as per section 131 of the OGST Act, my lords. Yes, I will take to my lord's attention some serials which is mentioned here, fine in lieu of confiscation. My lords may kindly serial number 1, INS 1, this is date of inspection, 8/1/23, my lords, here date of inspection.
8/11.
Yes, 8/11 is the authorization, Millers. INS 1 is authorization. And date of inspection 9/11/2023, Millers. And on the same day, serial number 2, this summon, it's a spot summon issue. Serial number 3, your lordship will find INS 02, it's an order of seizure, Millers. Serial INS 3, it's order of prohibition, Millers, prohibiting not to part with goods, Millers. Then summon, second summon, very same reproduction of the first summon. Then show cause notice, number 21, dated 6/1/24, which I will also just read out to your lordship, page 24. That is pertaining to penalty, Millers, 122 penalty, not 131. Then, Millers, serial number 7, Millers, time petition and reply of height annexure 8. All this I wanted to show to your lordship, Millers. There is a provision 130 subsection 4, Millers, that provides that opportunity of being heard shall be given before this drastic action under 130. 130 is a constitutional provision. It leads to deprivation of property, Millers, having serious civil consequences. You also kindly see section 130 subsection 4 for a while, Millers. I have also referred to the petition itself, Millers.
Same provision must be there. Just a minute. Yes.
Millers, 130 subsection 4, Millers. No order for confiscation of goods or conveyance.
Sorry, you are reading 130
subsection 4.
Subsection 4. All right.
May I, Millers?
Yes.
No order for confiscation of goods or conveyance or for imposition of penalty shall be issued without giving the person an opportunity of being heard, Millers. It is the one which is issued by Annexure 1, which I showed to your lordship, Millers. That is a show cause under section 122, not under section 130, Millers. And 130, it's an independent provision, Millers. It deals with everything, Millers. That must be.
This order has been passed under section 122.
122.
Not
and also
under
131. It's also 131. If your lordship will see the impugned order, the last page. Let me take my lord's attention to last page of the order. That is at page 89. For a while, my lords may kindly see.
page 89,
Yes.
the taxpayer is liable to make payment of the penalty equal to rupees 4,65,396 imposed under section 122 of the OGS Act as per section 131 of the OGS Act and fine to the tune of 62,05,260 in lieu of confiscation as per terms and conditions of demand notice in form GST DRC 07 by 15 to 24 grams. So now my humble submission before RCP is 134 has not been complied with. There is no Millard's show cause notice under 131, and there is no opportunity being had. Secondly, if your Lordship will see also for a while, section 130 subsection 1, there are 5 situations.
Is this your, just a minute, is this your submission? So why these two provisions are there, one under section 122 and the other under section 130 for levy of penalty?
This was also, this question was posed to itself by the Honorable Rajasthan Kerala High Court also. Court is at loss that when there is an independent provision for levy of penalty under section 122, there cannot be again any need of making re-legislation under 130 seeking to levy penalty, because 131
no, even without this provision, levy of penalty, the penalty could have been imposed under section 122.
Exactly,
independent provision.
Correct, Milos. 122 is the provision, Milos. No, my humble submission is 122 is fine because there is a show cause notice, there is a reply. Milos, and one more thing, my lords may kindly bear in mind, section 130 subsection very important. Subsection that is for quantification of fine. How fine will be imposed, Milos? That says there's a minimum fine and maximum fine, Milos. Minimum fine is the tax chargeable. Your Lordship may kindly see 130 subsection 2. It's a quantification provision and it has indicating relationship with tax payable. And that requires...
No, the difference between 122 and 130 is clear.
Yes.
For the reason that section 122 just delineates the instances where penalty should be imposed.
My lord.
All right. Whereas section 130 lays down the procedure for confiscation and imposition of penalty.
If I take your lordship's attention to 122 once again, my lords will find there is also provision for quantification. How will quantify?
No quantification, the procedure. Because section 130 only contains the procedure for imposition of penalty when it says that no order of confiscation or imposition of penalty can be passed without affording the person an opportunity of hearing.
Correct.
So that is there is no problem with having section 122 for imposition of penalty and section 130 separately for confiscation and the procedure for confiscation and imposition of penalty.
If your lordship will see 122 and reconcile with section 133.
There's 122 is nothing, but these are just penal provisions. 122 is just penal provision. It contains only penal circumstances.
Correct, madam.
So 122 is that only. 130 is confiscation and confiscation of goods or conveyance and levy of penalty.
Levy of penalty.
So there it is penalty and here it is levy of penalty.
Correct, Milos. There also levy of penalty. If your lordship will kindly see section 122 for a moment, my lordship kindly just see.
Here you
coach. Just a minute. Okay. There are 21 situations mentioned in section 122. Yes. These are the situations giving rise to imposition of penalty. And my lords may kindly see, he shall be liable to pay penalty of 10,000 rupees or an amount equivalent to tax evaded or tax not deducted under section 51 or not deducted or deducted but not paid to the government or not collected 52. These are the either 10,000 or tax.
Therefore, these are penal provisions.
Penal provision.
These are the 122 is just penal provision.
Correct.
133 lays down the procedure.
Absolutely.
How to levy that penalty which is imposed under 120.
Your
Are we
lordship
clear?
rightly said so. There is no dispute on this.
Only one addition.
No,
Fine in lieu
no,
of.
no, just
Let him come.
only point is, your lordship is right in saying so. Rightly, your
We
lordship
may
said
be
so.
incorrect, we don't know.
No, no, no. What is, in fact, here is the case. Section 130 is certainly a drastic provision because it contemplates the deprivation of property. So, whereas 134 is very important. That is a mandatory compliance. There must be a show cause notice. Opportunity being hard. The language used is opportunity being hard. I may be hard because the notice, the loan notice, only notice which your lordship finds from Annexure 1 in section 122. But I don't mind for taking note of the procedure, following it because your lordship rightly said so. Because I should have been noticed. I should have asked under section 131 to explain
No,
my.
we were trying to understand the distinction between 122 and 130. Now it's clear almost.
Correct.
Yes.
But that is not on dispute. So what is under dispute is, Millards, 130 is a self-contained code, Millards. It provides for granting opportunity. So called should have been under that provision. Opportunity should have been granted. And number two, so far as 130 subsection 2 is concerned.
Where is the appeal?
Sorry, Millards?
Appeal.
There is little difficulty. Your lordship knows that even if in some cases appeal is there, but how appeal cannot satisfy the whole of the thing so far as this case is concerned, the reason being, yes, I am ready because that will not cost me because as my lords knows, in other cases I have to pay 10% of the tax. Here there is no involvement of tax. There is only penalty and fine. So those are not amenable to any pre-deposit. So far as section 107 of the Act is concerned. But the question is, Millards, there is a provision again, Millards, under section 130 subsection 7 that provides that the goods so confiscated shall be disposed of not later than 3 months. They are bound to dispose of my property within 3 months and deposit the proceeds with the government, Millards.
So the appellate authority could have restrained.
So far appeal is concerned, Millards, on the contrary, appeal period is 90 plus 30. And within 90 days, I have to file appeal, another 30 days, say 120 days, and appeal disposal period is, Millards, 1 year, Millards. So, if
when was the order passed?
My order is 29 January only.
So you can go to them.
I can, but that will not satisfy the reason being
the appellate authority, he is better placed than the High Court exercising their jurisdiction.
Particularly, your lordship always pays concern where the procedures are violated under Article 226. My lord always pays concern.
We appreciate that.
And number two, Millards, particularly in this case, your lordship will find. So far as fine is concerned, the quantification fine is intricately connected to the specific, what is adjudged. He has to adjudicate. No tax is adjudicated. Nothing is adjudicated. Nothing is adjudicated, my lords. And what I am suggesting to your lordship, if your lordship kindly appreciate, because there is a provision under section 67(6) that applies to me because it's a case of seizure. It's a case of direction not to part with goods. Invoking that two documents.
No, but still you have the remedy, Mr.
What I am submitting, Millards, under section 67(6).
We are relegating the matter to the appellate authority. We are relegating you to the appellate authority. But we are happy that we have understood so many things in this series.
Before your lordship do that, before your lordship do that, Millards, what I am proposing, I am ready to pay, Millards, the tax and penalty that is contemplated under section 67(6). It says, if the dealer from whom, assessee from whom goods are seized, and those are directed not to be parted with, Millards, those are the situations, Millards, then section 67(6) that if the assessee pays the tax and penalty, the goods will release, Millards. 67(6), just for a moment, I am reading for a lordship.
Go and apply. You tell the appellate authority. The appellate authority will pass appropriate orders.
Because 107, once it comes to play, then the power will cease. So for 67(6), release power is gone. What I am saying, your lordship may direct me to pay the tax and penalty. Now it is quantified. Because tax is quantified, penalty is quantified. Let me deposit that amount. And subject to that, your lordship may grant release of goods, Millards, and I may be permitted to pursue appeal, Millards. And those are the cases.
Who will release your goods?
Millards, the proper officer, Millards, the opposite party number 1, Millards, opposite party number 1. Okay. Honorable Kerala High Court has also, Millards, in that spirit has directed, saying that this release of goods can be comprehended within section 131. It is not that you pay the entire fine and penalty, everything. So, Just one judgment of Honorable Kerala High Court.
No, but you want to pay the tax amount.
Yes, yes. I want to pay the tax amount and also
penalty
penalties. Yes.
And you want the release of.
Release of goods. And I will pursue appeal.
Fine, your lordship, fine is there. Your lordship may kindly look into
fine
page
is there.
89. Page 89 of the order. The order itself says
I will
that.
file
The
appeal for
order
that.
itself says that the impugned goods are confiscated and the taxpayer is required to pay the above penalty and fine to get confiscated goods released. Once my lord, once the petitioner pays the entire demand, your lordship, even on protest, your lordship, and file appeal. So the goods can be released by the assessing officer. The assessing officer himself has
Cannot
stated.
be released.
But
Just a minute. Section 67(6). Just I'm letting you place before my lords. Section 67(6) is a statute provision. The goods so seized. Section 67(6). My lords, may kindly spare a moment. Section 67(6).
Yes.
My lords, the goods so seized under subsection 2 shall be released on a provisional basis upon execution of a bond and furnishing of a security in such manner and of such quantum, respectively, as may be prescribed or on payment of applicable tax, interest, and penalty payable as the case may be. Here I want to exercise the second option. I want to pay minutes. The tax is 3%. I am a dealer, a small associate dealing in ornaments, Milos. It is liable to tax 3%, Milos. I will not burden your lordship with facts.
So you will go for this.
I will
or
go
on
for
payment
this.
of applicable tax, interest, and penalty.
Correct,
payable.
Milos. Penalty is 4,75,000 and penalty is 100% equivalent of tax payable. So 4,75,000 plus 4,75,000. Together I am ready to pay, Milos. And let the fine issue be adjusted by the appellate authority. I will file appeal there. Only I want release of goods, which this provision provides.
Where is the why will they not release? This is the question.
Yes, they are not.
Why are you making the submission? Why do you apprehend that they will not release?
Yes, now, by virtue of annexure 6, annexure 4, they say you pay the entire fine, penalty, then only will release goods. That's the problem.
You are saying that you will pay fine, penalty, and tax.
No, not fine. I will pay tax and penalty. 67(6) provides for tax and penalty. They say you pay fine. I say I will carry appeal for fine. And you take tax and penalty and release goods. That is what
is the amount of fine?
Sir, fine is 62 lakhs.
Where
Which
is
is
the
beyond
order?
my capacity. I cannot, even on fact also.
Page 89.
Where is the
Page 89, my lords. Page 89. And calculation is given in page 88. It is a matter of adjudication. Let that be decided.
Here, your lordship, there is no demand of tax, your lordship. Here only the demand, it is 130 proceeding, confiscation proceeding. Here the demand is only penalty under section 122 and fine in lieu of confiscation under section 130, subsection 2, your lordship. So there is no question of tax demand here. So this section 67 does not apply so far as this section 130 is concerned. Your lordship, only if he has to release the goods, he has to make payment of the enter penalty and fine.
Sorry,
Your
page
lordship,
88
kindly-
it says tax.
Here, your
Page
lordship,
88
kindly-
tax.
See, this section will not apply.
Your
Section
lordship.
67 will not apply because 67 is pre-confiscation.
Pre-confiscation.
So-
And that is what I am challenging because confiscation under the facts is not warranted because that procedure not followed, Because mandatory procedure not followed. Not followed.
There-
So,
there-
and what my learned friend is telling me, that there is no question of tax. Fine is intricately
No.
based on tax only.
No, wait.
Requiring adjudication.
See, you have approached this court without filing. Then you are referring to section 67(6)
My lord.
of the act, which is not applicable in your case.
No, because certainly two documents that is not in your lordship's record, because it's not legible. So to prevent all that, I have not filed, but I have brought along with memo. I am submitting to your lordship.
We will not even try to see those documents, which are not there on record.
No, I understand because that is why just to assist your lordship, giving a memo only.
Sorry,
which,
sorry.
Usually
Sorry.
I understand.
You better If you file an appeal, we will give you liberty to make an application for release of the goods that shall be decided in accordance with law. But we shall not refer to this provision which is not applicable.
But may I tell my lords one thing, lords? So for a section, because they are statutory authorities, section 130 says, if I pay the entire fine and penalty, then only it's very simple language is there.
Let us see.
My lords, yes, my lords may kindly see. Section 130, which the Honorable Court has read down in other cases.
Read down?
Yes. Read down saying that even in absence of the word provision release, but court can read into and such a benefit can be granted.
Where is that?
Well, so 130, my lords may kindly see for a moment, for release of goods, 130 subsection 2, my lords. 130 subsection 2, my lords.
Yes.
My lords, whenever confiscation of any goods or conveyance is authorized by this act, the officer adjudging it, the language is very important, adjudging it, shall give to the owner of the goods an option to pay in lieu of confiscation such fine as the said officer thinks fit, provided that such fine leviable shall not exceed the market value of the goods confiscated, less the tax chargeable. That it's a very higher side. It's a higher market value, not tax. Provided
Just
further that.
Please give us a minute.
Sorry, madam.
Please give us a minute. So again, of course, this is our tentative view. So this provision will also not apply because this is also pre-confiscation.
Because Honorable Kerala High Court said that pre-confiscation, post-confiscation, because supposing mirrors is confiscated, then mirrors this will not help because
yes, if goods are confiscated, then the situation will change. Subsection 2 will not apply.
But they say you paid, otherwise stands confiscated. Let's see like this.
Yes. If you pay here, you allowed the goods to be confiscated. You could have availed this benefit under
and the proviso
subsection 2 of section 130.
Correct. Proviso says, Bilars, the minimum is 3% is the rate of tax here.
No.
And they have levied 40% of the goods value.
Maybe in this case, the confiscation proceeding is over. The goods have been confiscated. Then where is the question of invoking subsection 2?
No, subsection 2 says if I pay now, they will
not now. At the time where confiscation of an goods or conveyance is authorized by this act.
Where confiscation of any goods or conveyance is authorized by this act, not already confiscation matter, authorized by
Absolutely
correct. Absolutely correct.
The officer adjudging it. So during the process of the confiscation proceeding, during the process of confiscation proceeding, that authority shall give to the owner of the goods an option.
Yes.
To pay in lieu of confiscation.
Yes.
Such fine as the said officer thinks fit.
That is what they have done in Annexure 4. They say in lieu of confiscation, you pay this much amount, 62 lakhs.
No.
Yes, sir. Yes. Sir, kindly, yes. I think there may be communication. My lords may kindly see. Annexure 4, page 88, then 89. Yes. 88, 89.
No, Mr. Sorry.
Page 89, paragraph 26. The last paragraph, my lords may kindly see. The impugned goods are confiscated and taxpayer required to pay the above penalty and fine to get the confiscated released. My lords may kindly see, paragraph 26. So he has directed, pay fine, get it released.
Oh, just a minute.
My lord. And preceding passage in lieu of confiscation.
Yes, Mr. It appears to be correct.
Your Lordship, it can be done. Your Lordship, at page 88, it is as per our subsection 2, Your Lordship. And this order has been passed pursuant to subsection 2. Your Lordship may kindly.
This order is under subsection 2.
Under subsection.
Not a final order of confiscation.
Your Lordship, Your Lordship, this is the 130 order. Your Lordship, if the goods have been seized, if he will pay the amount, the penalty as well as fine, penalty under section 122 and fine as per 130 subsection 2, then the goods will be released. If you will not pay by the pay by date, Your Lordship, then the goods will be auction confiscated, Your Lordship. So this order has been passed after Your Lordship perjury. And the amount you are here, Your Lordship, the amount is as per subsection 130, subsection 2, Your Lordship. Your Lordship may kindly look into that 40%, Your Lordship, the proviso of 130 subsection 2. Provided that such fine leviable shall not exceed the market value of the goods confiscated, the less the tax chargeable thereon. Your Lordship.
No, Mr. If we read paragraph 24,
Your Lordship,
you are required to release
Your Lordship,
the goods once the petitioner pays the amount which is mentioned there.
Exactly.
62 lakh or something.
Your Lordship.
So that you will have to do.
Your Lordship, we have stated so. I have, at the beginning, I have submitted that. Once you will pay the fine and penalty, then the goods will be released, Your Lordship.
Only point is, Milords, that 62 lakhs, which is linked to Milords levy of tax, because that 62 lakhs is relatable to adjusting the tax payable.
So whatever, it is mentioned in paragraph 24 itself for the order.
Yes. Because
it is clear. So even no order is required to be passed by this court that if you pay this much of amount, then your goods shall be released. Because it is there in the order itself that if you pay this much of amount, the goods shall be released.
The problem why I am before Lordship, Milords, because 130 subsection 4, Your Lordship have seen, Milords. Opportunity of being hard.
That we will see.
So called under section 122, not under 150. Otherwise, I don't have money, Milords. 62 lakhs is too, because 3% is the rate of tax. My tax liability is only 4,95,000. My Lord may kindly think of my tax liability. Therefore, Honorable Kerala High Court has interfered, saying that yes, this court has power to direct provisional release of goods. My humble submission is because I am an assessing.
No, this court is not powerless. It is not that.
Correct.
We do have the power.
No,
the
but
question is where to.
Your Lordship have striken a balance. Tax only 3%. And they say you pay 40% of the goods, market value of goods. What do I stand, Milords?
No, but by this time you could have gone to the appellate authority.
Appellate authority, my Lords knows they are helpless because the reason is unless I pay the fine, they will not direct because they don't have power. Appellate authority has also no power. But my Lords may kindly visualize. They don't have the power, Milords. Will be there, but for no consequence, Milords.
You can come.
And 3%, 3 months time is there, they will now sell it. Because that is your statute provides, you dispose of not later than 3 months. Even if I approach appellate authority, within the appellate, period available to me at the latter stage, by that time also conflict would have been over. Just time, even if I seek the remedy, within appellate time, appellate period, at the latter end of the appellate period, then also by that time they would have confiscated. Sold out, disposed of the goods. So appeal ultimately, that is why Your Lordship may kindly strike a balance. Because I am a registered assessee, Milords. So everything is there. I am place of business under that domain, Milords. 226 just to strike, because for 3% tax, and where do I stand when 40% of the value, market value is demanded by your fine? That is why I suggested to Your Lordship, I am ready to pay the entire tax payable.
So you can, again we are reiterating that all the submissions which you are making before this court, you could have made that before the appellate authority. And the appellate authority has all the powers to pass any interim order or decide the matter.
So in view of 132, do my Lords think they will exercise power? They have any power at all? 132, my Lords have seen now. In view of section 130, subsection 2, do the appellate authority have any power, my Lords, to interfere, even in the interim stage, to grant any interim relief?
No, yes, they can. The appellate authority has all the powers. Once you are in a position to satisfy that the order is completely without following the requirements of the statutory provision, the appellate authority may grant you a stay.
Their statutory authority belongs. They are bound, even tribunal also. They will be bound by the statute only.
Then the
Except
matter
your
should not
lordship.
go to the appellate authorities. The matter should not be sent to the tribunal. All the matters should come to the High
And they
Court.
can't set aside either. So, if your lordship is relegating me, because my humble submission would be, let them dispose of within the period allowed for disposal of goods. Otherwise, as my lordship will be enforced.
How much time do they take in disposal of appeals?
Normally, statute says 1 year, but they have the power to do even take up immediately on urgent basis. These are the situations where they can act urgently.
And senior counsel appearing on behalf of the petitioner while assailing the impugned order passed by whom?
Passed by opposite party number 1.
Passed by Deputy Commissioner State Taxes. देख लेना opposite party number 2. Opposite party number 2. Bracketed opposite party number 2.
Yes, opposite 2.
Opposite party number 1. Dated 29/1/2024. Has agreed that the petitioner has alternative remedy of statutory appeal against the said order. So stop. The impugned order, operative portion of the impugned order reads, order passed under section 130 bracketed 2 of the Odisha, what is this called? Odisha Goods and Services Tax Act 2017, reads as under at page 88, paragraph 24 to 26.
Let's see, I'm sorry, let's see.
20.
Let me leave you, the order passed under section 122, read with section 130.
122.
Read with
section 130.
130, bracket
131.
And also 130, bracket 2.
131 and 130 bracketed 2 of so and so act. Oh, stop. He, however, submits that in the light of what has been mentioned in the impugned order, the petitioner has been asked to pay a sum of rupees 62,05,260 in lieu of confiscation of good in lieu of confiscation of the goods though full stop. he contains that the impugned order has been passed in total breach of the principles of natural justice and subsection 4 of section 130 of the said act. This is submission.
I may be permitted to point out one thing, Your Lordship, at page 71, I'm sorry, at page 71, Your Lordship may kindly look into. At page 71, the notice has been issued, Your Lordship, that has been adjudicated. He has filed submission, he has appeared, the notice, the reply has been adjudicated.
No. Therefore,
Sorry.
and that is a submission. We are not adjudicating upon that. He has submitted that the court may direct the appellate authority. He has submitted that if the petitioner is relegated to the appellate authority, the appellate authority may also be directed to consider the petitioner's prayer for a release of goods if the petitioner complies with the requirement under section 67.
67(6), subsection 6.
67(6) of the Act. Stop. In our opinion, 67(6), bracketed 6 of the Act shall have, should we mention that? Or you may take that plea before. Otherwise, it will be difficult for you. Stop. Without expressing any opinion on the contention on senior counsel's contention, we dispose of this writ application with liberty to the petitioner to prefer an appeal before the appellate authority. Stop. Learned senior counsel has vehemently argued that if the appeal is not decided expeditiously, there is likelihood of the goods being disposed of.
Under 130, subsection 7.
Under section 130, bracketed 7 of the Act, which will be to the detriment of the appellant's interest. Stop. In such view of the matter, we observe that the appellate authority shall ensure expeditious disposal of the petitioner's appeal if it is filed within a week from today, preferably within a period of today. Stop. The petitioner shall be at liberty to seek any interim order from the appellate authority during the pendency of the appeal. Stop. The court expects that the appellate authority shall look into such aspect of the matter with due promptitude. Anything?
Your Lordship, only in the first paragraph, Your Lordship has detected so far as the fine is concerned. Penalty as well as fine. Penalty 4,65,396 and fine 62 lakhs. Your Lordship only dictated the fine.
Penalty and fine. Penalty and fine.
Both penalty.
132 says
4,65,000.
Whether penalty is beyond 62 lakh or penalty
beyond
includes
beyond
penalty and fine.
Within 3 months, your lordship,
Penalty.
your lordship is clarified. Within the,
We don't know their roster.
correct.
Your lordship may, without expressing any opinion on merit.
We,
No,
we,
As per law,
not
we-
necessary.
we make it clear that we have not gone into the merits of the case. Sorry, we got late. Yes.
Item 25.
May I please proceed? Well, the petitioner has been declared a successful L1 bidder, but he is required to deposit the additional performance security with the tendering authority within a period of 7 days. But his misfortune is that he has been admitted in the hospital and remain hospitalization till 28th January, my lord. And immediately he prepared the additional performance security on 29th and gone to the authority for deposition before the authority. But they have not issued it. Rather, they have issued a show cause regarding blacklisting of the petitioner for non-compliance of the tender condition. I have relied on his judgment of the appeals court in the similar circumstances. I have quoted in and also I have brought that judgment.
So have you come against the notice?
Yes, my lord.
So notice you.
No, my lord. Notice but one thing, my lord. What I submit to my lord. This is work has been already also can for moment page 30, my lord. Page 30. Annex 2, my lord. That is issued on 16th December 2023, my lord.
Yes.
With reference to the subject cited, it is informed that your tender for the above mentioned work has been accepted by the additional chief engineer, Daniel Circle, Bhubaneswar, for an amount of rupees so and so, only being 14.99% less than the amount put to tender. Hence, you are requested to attend this office with the additional performance security amounting to rupees so and so, within a 7 days. Letter for verification of this one. Lordship can see next page 31. On 19th December, my lord, he has been hospitalized because of the could not be complied with the same. Only, my lord, she has also with the legislative exception to execute the work, also purchased several high value machines for achieving the public work in time. I have also annexed the same. My humble request is, my lord, the power of regarding or dispute regarding tender acceptance or any conditions. He is only due to beyond his control, impossible.
So you can respond to your so-called notice. You can tell them.
My lord, I have already filed. My lord, lordship can see annexer 5 series. I have also approached the opposite party number 1 and 4 series and 5 series I have already brought to the notice of the authority. Now that is pending before the authority.
That they will take this. So far, you have not been blacklisted.
No, not pretty blacklisted. But my humble request, my lordship, is, my lord, because your lordship in the similar circumstances, 3 days, 4 days has been because of laches due to not deposited the security amount, and the Supreme Court has the other side, the other bidder has challenged the same before the High Court, Bombay High Court bench. The High Court has set aside the quash the offer of tender and directed for the issuance of fresh tender. The petitioner carried matter to the Supreme Court. Supreme Court has referring to the maxim of impossible clause, my lord. Thank one moment, it's my leaving with my lord discussion. I have quoted that, but lordship can see. Only I am bring my lord's discussion because his amount has been invested. Lordship can see the page para 1920, my lord. 19 and 20. This is a case where the appellant has complied with the condition of furnishing the additional performance security at the earliest possible time that it could possibly comply, that no one can be compelled to perform an impossible task lex non cogit
which paragraph you are reading?
Para 19, 20, 21, my lord.
Paragraph 19. Yes.
This is a case, my lord, the amount what is performance security could not deposited. This is a case where the appellant has complied with the condition of furnishing the additional performance security at the earliest possible time that would possibly comply, that no one can be compelled to perform an impossible task lex non cogit and impossibilia.
So some impossible task was required to be done by you,
my lord.
What?
By within 7 days I have to deposit, my lord, because of illness. My illness I could not deposit this year.
It is very difficult. How can we hold that you were in fact unwell?
I have annexed all the documents, my lord.
The documents are not duly verified.
But I giving my lord's discretion, my lordship take a sympathetic view, my lord, because of huge amount is already invested. Let the authority opinion number 1 to take a decision on my representation on annexure 5. And till the decision is taken, no course of actions are taken against me, at least, my lord. Because ultimately
we don't know what will be the fate of your case. But in no case you can rely upon the decision of the Supreme Court in this case.
No, I have
It's
only,
entirely
I am relying, I only bring my lord's recession because these in circumstances
entirely
that can
different thing.
only, I am not, my lord, claiming a legal right that because I am defaulter. I know that.
Yes, but you are
That's why-
defaulter, and it
This is-
cannot be your case that what you were required to do was impossible. They were asking you to do
My
something which was
impossibility, my lord,
impossible.
the impossibility.
It was impossible because you were not well.
Well, that's why
According to you, you are relying on some certificates granted by some hospital. Whether those certificates are correct or not, that is
My
yet
lord-
to be gone into.
What I beg to pray, my lord, lordship, submission, my lord, kind attention, my lord, lordship, let the option number 1 to dispose of the matter annexed.
Urvashi Clinic, you went to Urvashi Clinic, cough plus something.
My lord, the lordship, that is
No fever.
My lord, lordship, by page 31, that is admitted on 19/12/2023, my lord, and he has discharged on, my lord, page.
What discharge?
Released from the hospital on 28th January 2024, page 44. That is right hand side indicated, my lord, date. Only, my lord, because of I invoking my lord's recession, I know that.
Sir, it seems that the documents on which you are placing reliance are fabricated.
My lord, I cannot.
Yes.
My lord,
You cannot say. You cannot say. But
because
tell us,
the documents has been
tell us
supplied to
which
me.
element you are suffering from.
My lord, that is that indicated in the page 31.
Yes.
That the medical papers, ECG, other things has been done at page 32, 33, 34. All the tests were made, and ultimately the page 45 shows. Page 44 shows he has discharged 28 January 2024, my lord.
Sir, you went into the hospital according to you. You get yourself admitted, and then you remain there in the hospital, get discharged after some time. But what was the ailment?
Ultimately, my lord,
Your client is befalling whom?
before the, my lord, Dr. Niraj Kumar Sharma, who was the physician looking after the patient, my lord, page from
What had happened? What was your ailment?
My lord, element is there, that is in the page 31, that is in the initial indicated.
Read it.
Cough.
Cough.
Feels a bit breathless, and this man smoker.
How can you come with this plea? That too in the High Court.
No, my lord, because of lordship can see there.
Because of Mr. Counsel, we are again asking you to tell what was the ailment your client was suffering from.
But from this document, you heard.
You cannot say anything. Have you stated anything in your application?
Only I have stated what the medical papers, that is in
Medical papers. What is this?
Discharge.
What is this?
May I pray lordship discussion, lordship.
Nothing.
Request the lordship to discuss and to only consider. Otherwise, my lord, because I will face severe consequences because I have already invested so much money to execute the work, public work. Even if, my lord, the tender will invited face again, then it will take another much more time because I have also 14.99% less than the.
See, in no case we shall interfere in such cases
I agree.
with such pleadings, with
Fine.
such documents on record. You cannot make mockery of the writ proceedings like this.
Only because of.
You are saying that you were admitted. You don't know which element you were suffering from. You are relying on Supreme Court's decision which lays down a law that no one can be asked to do something which is impossible.
No, my lord, I am equating myself
What is
because
this?
of the period of non-deposit regime. Regime for
See,
non-deposit, I am equating and bringing my lord's situation only.
We are disturbed about the fact that your client has courage to approach the High Court with such pleadings.
Lordship, permit me, I have to get
Very
medical
serious.
papers. Or lordship,
Very
my lord,
serious. Or if you see, if you want, we can direct for an inquiry
my lord, I may not
about the ailment which you are suffering
My
from.
lord, I have no audacity to my lord, say, my lord, lordship, my lord, what I make a submission from my client. Lordship, then permit me to withdraw the
You
requisition
better don't
of-
press the application, otherwise you take your plea, whatever you have to take before the authority which has put you to notice.
Only lordship, I get direct the only observation to disposal without expressing opinion. Lordship, direct the opinion number 1 to dispose by Annexure 5 query, my lord.
Why? What is Annexure 5?
Annexure 5, my representation along I have narrated everything.
Representation against what?
And regarding this, my lord, improvement to the entire work and everything, my element and including my lord.
No, sorry.
Lord, see, can page 48 one moment.
Sorry, we will not do
That has been duly acknowledged by.
not with these affidavits. No, with this pleading. This pleading.
Pray, Lordship.
We are unhappy. The manner in which you have brought on record the certificates, the manner in which the pleadings have been brought on record.
No,
We are
my
not
lord, only Lordship is subject to my lord's permission. Only I will discussion, my lord, only discussion is because of his position, because he could not deposit it within 7 days. Now they have deposited the entire amount, page 49. They have already said that is there, my lord. If the work will execute in the public interest, he will execute because he has also had
public interest. Why are you so much interested in public interest?
No, and the work has to be done, my lord, achieving the.
So you are interested in public interest or?
No, my lord, I am only making submission, my lord, only to request to lordship's discretion. If my lord permit me to withdraw the report to approach the authority for redress
That you
of
may do. And counsel for the petitioner, after some argument, seeks permission to withdraw this application with a liberty to approach appropriate authority under the state government.
OP number 1, my lord.
OP number 1 for the redressal of his grievance. So stop. Without expressing any opinion, the said application is dismissed as withdrawn with the liberty as sought. Please be careful.
My lord.
Item 26.
The authority is the OP number 5. Opposite party number 5 is the authority.
Opposite party number 5.
Yes. That is the tendering authority. Executive engineer is the tendering authority. What issued the
Additional chief engineer has invited the tender, and only the OP number have made the representation to the authority, the other department, which
page 30 annex.
Where have you filed your representation?
Before the OP number 1, my lord.
All right, wherever you want to go.
Item 26. All these contempts, I pray, Lordship, they did granting 6 weeks time. In the meantime, we'll see that is complied with.
That is the last.
Yes, only last.
Not the second last.
See, I'll try to get it complied within
All
6
right.
weeks.
All right. In the background of the assurance given by learned AGA, this matter is adjourned to 6 weeks. So as to report full compliance of this court's order, violation of which has been erased in the present contempt application. This case on.
27. That's my humble request is up to 36, all similar matters. Plus you can direct similar order in up to 36 minutes.
I don't 27 is specifically directed to dispose of the in personal appearance presence of the authority, specifically directed to the disposal of by 3/1/2024. In meantime, near about 1.5 months already passed, but that is not complied.
All right, let it come after some time. 6 weeks we are granting.
Item 48 minutes, I have entered 2 years.
Just a minute. Your matter has been called.
28. Within that, 28. I say from 27 up to 36. If my friend wants to press it, then
28
no,
20. Yes.
Yes. I'm for the state, he is for the Walmi.
Yes.
I'm for the state, contempt number 1, he is for the organization under me, Walmi. So all cases I said 6 weeks we will comply.
We will comply.
Any problem?
It will defer. The contempt will be taken up after.
All yes, cases are lying. He says that we dispose of it. Has not.
Yes, it is lying over.
No, we are not disposing it.
No,
we will ensure that the orders are.
Yes.
Compliant. We will not permit any second contempt application to be filed. So either they would be complying the orders or they
face the consequences of contempt. Try or not.
Malak, is possible if date may be fixed, Malak?
Date will be there.
Up to serial number 36 is called up. Item number 37. Item 37.
Withdraw. Withdraw. Memo taken on record.
Item 38. Item number 38.
Become infructuous because 2018 matter. The conducting council, in the meantime, he has passed away, my friend, Mr. Sai. And the prayer is construction of community center inside the village. And we have filed a counter affidavit saying that no, it's not in violation. After due permission from the state government, some amount has been sanctioned for construction.
Could we dispose it off? He's dead. Third council is for the petition.
It's a public related, yes, ma'am.
This writ petition in the nature of public interest litigation was filed seeking direction to seek what direction?
Direction not to construct a village community center inside the village millers. Page 2 of the prayer, your lordship may say.
Which page?
Not so.
Prayer is not clear.
It's
Is
page 7 millers.
all right.
Further direction be given to the directing OP number 2 not to make any construction of Kothagara, that means a community center millers on the
Just a minute, just a minute. Yes. Someone is saying something. Has someone joined online? No, huh?
Not moved, but some noise came.
Online. The this writ application. Seeking direction restraining opposite party number 2 not to make any construction of Kothaghar.
Yes, it's a community center inside the village.
Kothaghar bracketed community center
Yes, not so.
on the which land? Common land.
Yes, ma'am.
No. Communal. What is that? And not to allot the said land for the purpose of such construction as per a work order already issued, bracketed annexure 4. Next. Learned AGA appearing on behalf of the state opposite parties has submitted that this writ application filed in the year 2018 has become infructuous for the reason that what stand have you taken?
Plus, I have stated that, if you also have filed a counter affidavit, we have stated that after making due inquiry and obtaining permission from state government, 2,05,000 has been sanctioned for construction lots.
It has been constructed.
That instruction I don't have.
That the present writ application appears to have become infructuous. First off, in any view of the matter, the site was selected for construction of Kothaghar after due verification.
And suitability report, Milords.
And a suitability report. First off, considering the nature of grievance raised in the present writ application and the stand taken on behalf of the estate, we see no reason to interfere. First off, this application stands dismissed accordingly.
Item 39. Item number 39.
I am for the respondent 2 to 5. There is a delay of 3 days. There is a delay of 3 days in preparing the appeal. That can be condoned without recording our concession. That can be condoned, madam, without recording my concession.
So this matter has come for condonation of delay.
Yes, madam.
This is which matter? This is
39. Item 39.
16479.
Read appeal number 1368 of 23.
Double 1368.
1368 of 23, madam. The appellant has filed the appeal with without recording my concession.
Oh, yes.
Because I'm appearing for the bank, that is right.
IN number 3577.
3579.
3579. IN number 3579 of 2023. For the reasons stated in the application, delay in preparing this appeal stands condoned. This application is allowed.
My lord may call this matter for fresh admission, my lord.
List this matter for
Day after tomorrow.
appropriate hearing. When?
Day after Friday, my lord.
What is the system? No. List this matter for admission on 2 weeks.
Obliged.
Item 40.
Item 40, my lords, the university is before my lords in appeal against the my lords judgment. There is a direction that ought to regularize all these employees working in my lords, the ladies hostel and other hostels. My lords, no post, they were not appointed against the sanction post. Their appointment was in the year 2013. Admittedly, they completed 6 years, but they say that a scheme should be implemented so that they should be regularized. That is what we have challenged. My lord, there is a delay in filing these matters. There is a delay of 200. 220 days, my lords.
So if you notice on the point of limitation. Point of limitation, we are issuing order. Requisites within.
May criminals, I will take Dusty because he's working in university. Normal contempt is staring at us. Contempt is fixed, my lords, to 3rd of March, my lords. I will take notice through Dusty. I will serve him so that my lords short date can be fixed and this can be taken off on that.
So when was the contempt filed?
Contempt filed, my lords, contempt was filed, my lords, after this. Was the number? My lords, 6443 of 2023, my lords. 8/11/2023.
Contempt application was filed when?
8/11/2023, my lord.
And when did you file this appeal?
Well, that is on 5/9/2023. We filed it. But there was some problem, my lords, it could not be listed because acting Chief Justice, my lords, who passed that single bench order, my lords. That is why some we tried, but we could not be able to get it listed, my lords, in spite of memos filed.
All right, we are not issuing notice.
My lords.
We are adjourning the matter for Monday. On Monday, you request learned counsel who is representing the
the petition, opposite party, respondent.
Opposite parties in the contempt matter. We will consider passing appropriate orders.
Right. I will serve that. I'll serve. I'll also inform my lord that that will be taken up on Monday.
List this matter on Monday. Stop. Learned counsel appearing on behalf of the appellant university has submitted that a contempt proceeding is pending. Contempt case is pending for alleging deliberate disobedience of this court's order. Disobedience of the order passed by learned single judge, which is under challenge in the present appeal. Stop. Judgment dated 20/12/2022, passed in WPC number 9247 of 2020. Stop. Learned counsel for the appellant may inform the learned counsel representing the private opposite parties in the present case. Representing the petitioners of contempt petition. That is
number 6443 of 2023. 6443
of 2023 about the pendency of the present matter and the fact that the same will be taken up on next Tuesday. Tuesday. Shorten the period of notice service.
So placements that solved by purpose.
Item 41.
Your Lordship, item 41, permit to withdraw.
Withdraw.
Item 42.
May I please, my lords? My lord, this writ application has been filed challenging the order passed by the learned Central Administrative Tribunal. But this has a checkered career because although it was filed in 2004, it got dismissed and the learned counsel appearing for the petitioner also is dead. But it was restored again in 2023. Thereafter it was listed for fresh admission and this honorable court issued notice in the last occasion.
So what have you challenged?
My lord, here what has happened is the petitioner, that is opposite party before the learned tribunal,
he joined as the repeater station assistant, that is erstwhile telephone and postal department in the year 1969, so
No, no,
71.
this writ petition has been filed for what?
For challenging the order passed by the Lanai Central Administrative Tribunal.
Where is that order?
My lord. Annexure 3 to the writ application. That is page 36. May I say the background of the case, my lord?
Just a minute.
Sir.
So you were in service for slightly more than 10 years.
I am for the department, my lord, the opposite party.
You are for the department.
My lord. I am challenging the order passed by the Lanai Tribunal.
So he was in service for
10 years.
10 years,
Yes.
slightly more than 10 years.
Yes, 10 years, 8 months and 29 days.
10
My lord,
years, 6 months.
Yes, he joined in 6/6/1971 and tendered his resignation on 5th of December 1981,
Yes.
seeking for better job. Thereafter, he filed this OA in 1999, after a lapse of around 18 years, saying that since by the time I resigned from service, I had completed the qualifying service that is more than 10 years, so I should be given the pension. There, the objection was raised by the department saying, as per my lord rule, the pension is being regulated by the CCS pension rules. So as per rule 26(1),
Resignation disentitles.
yes,
Yes.
unless the resignation is withdrawn or it is permitted to, is allowed to resign, then in that case, the past service rendered will be rendered infructuous. May I place my lord rule 26(1)?
So is that an admitted fact?
That is an admitted fact. Forfeiture of service on resignation. Resignation from a service or a post, unless it is allowed to be withdrawn in the public interest, by the appointing authority, entails forfeiture of the past service. Then clause 2 says, a resignation shall not entail forfeiture of the past service if it has been submitted to take up with proper permission another appointment, whether temporary or permanent, under the government where service qualifies. So here is a case in the resignation letter. He has stated that I want to go for a better job, and he resigned. That was accepted and he was relieved. Thereafter, he is filing a case after 18 years saying, since by then I had already rendered 10 years of service, I should be. The Lanai Tribunal, Malaji, interpreted the word resignation as retirement and passed the order saying that since he is qualified. But here the relevant provision, my lord, the qualifying service, the relevant provisions which deals with the qualifying service are Rule 3Q, Rule 5, Rule 20, Rule 48, Rule 48A, and Rule 35 of the CCS pension rules. And normally, he should have retired after the rendering the entire period of service, that is superannuation. That is Rule 48. Rule 48 says, this says that he can also retire, he can also take a voluntary retirement after rendering 20 years of service. That too with the permission of the and giving notice of 3 months. But here is a case, my lord, he has simply, it was a resignation simpliciter, and he wanted it to opt for a separate job. And he is challenging it after 19 years. The learned tribunal has not dealt with this. Specific objection was also raised in the counter affidavit with regard to limitation. But by the time he was relieved, Administrative Tribunal Act was not there. It came in 1985. Lord, the court functions since 1986. He did not choose to file the application saying that this was a technical resignation, so I should be given this pension. Then he could have also very well come before your lordships under Article 226. But he waited since 18 years. After 18 years, he has come and filed before the tribunal and saying that I should be given pension because I have rendered more than 10 years of service, which is not allowable in view of Law 26(1). The learned tribunal says that resignation amounts to retirement, so you have to, without discussing anything about this 26(1).
Yes.
Lordship, I resigned from the government, from the services of the government of India to join the services of the state government, that is state of Odisha. So while resigning, I had already given the resignation. In the resignation letter, I had mentioned that I had taken already the permission. I have already taken the permissions, and now I may be permitted to join the services. I was thoroughly relieved. Lordship, I joined in 1971 and I was relieved in 1981. My exact qualifying service is 10 years, 5 months and 29 days. So there is an office memorandum, 1965 memorandum says, Lordship, this is a technical resignation. So in case of technical resignation, then the 26(2) comes into force, which says there shall be no forfeiture of services. I may be permitted to read
26(2) of what?
Of CCS Pension Rule 1972. I have the book.
Yes.
Lordship, I have quoted it in page 8 of the counter. 26(2). A resignation shall not entail forfeiture of past services if it has been submitted to take up with proper permission another appointment.
Just a minute. What is the definition of the government? How the government has been defined under the rules?
That is central government.
Then, did you join any department under the central government?
No, Your Lordship.
Then, how are you relying on this?
Lordship,
please read it again. A resignation shall, just a minute. A resignation shall not entail forfeiture of past service if he has been submitted to take up, if it has been submitted to take up with proper permission another appointment, whether temporary or permanent, under the government. So under the government would mean under the central government.
Lordship. But in the Government of India decisions afterward, the memorandum I am relying upon, 1988 memorandum and 1960 memorandum, it is clarified that the state governments and the PSUs are also covered under the government.
Yes, but in that case, that those governments will be paying, the PSUs may be paying only if this service is transferred to the government, like his provident fund amount and everything. Had those been transferred to the government, the concerned government, state government would have been paying you the pension. But how can you invoke? Let us see which government of India decision you are relying on.
Lordship, page 23 of the counter.
Page 23 of the counter.
Counter affidavit.
There is no book.
I have annexed the memorandum.
So you have annexed the memo and you want us to read that memo without that having been properly verified in accordance with the provisions of the High Court rules. That memo is nowhere in this book.
Your Lordship,
Then where from have you taken that memo?
it's there in the book,
There in which book?
in CCS pension room.
With CCS pensions we are having. We do have the book. Where is that? Don't get nervous. Please examine. Please examine. Come later. Come prepared. Address the question. You are relying on Rule 26(2). You are right. If you would have been right had your client joined some position under the central government. That would have been different. And there is reason why the two provisions are there. One, when it will entail forfeiture of pension, and two, when it will not. All right. And then you don't have any explanation for delay.
Lordship,
No explanation for delay. See, here a situation is that your employers are two. So had you joined the central government, your employer would have been one, the central government. And in that case, the period of that could not have been forfeited because you were serving the same government. Now here you left one government by resigning, joined another government. It was purely a fresh appointment, employment. How can you claim?
Lordship, I'll prepare.
This is our tentative view still. You may persuade us. As requested on behalf of the opposite party member for the sole opposite party. List this matter and matter on 2 weeks. Stop. In the meanwhile, the parties shall be required to file their affidavits verifying the averments made in their respective pleadings. Both of you.
Item 43.
I'm for the opposite party.
What is this about?
I am for the opposite party.
What is this about?
That the bank issued the notice under section 22 under the Securitization Act, and thereafter the position has been taken. This honor court passed a conditional order of stay of that notice.
Then when there is no representation, we can dismiss it.
Yes, sir.
There is no representation on behalf of the petitioner. This writ application is dismissed for default. The interim order stands vacated. Interim order is there?
Yes, ma'am.
Stands vacated. Post of learned counsel for the opposite party number.
All the opposite
parties is present.
Item 44.
Yes, in this item, I was directed earlier to file an affidavit of the concerned Tahsildar. I need a week's time. And furthermore, so I will file that affidavit within 1 week.
Which affidavit?
Affidavit was directed to be filed by me by order dated 30th of January. So that affidavit I could not file because it was directed on 30th. Only week's time I need. And further, my friend may also file that supplementary affidavit with regard to that. Both will file within a week, or my friend may.
1 week further time is allowed for the state opposite parties to file an affidavit
No.
in compliance of this court's order dated
30th of January.
31/2024.
No.
File an affidavit in the light of the order passed by this court on 31/2024. Stop. And requested list this matter on 2 weeks. Stop. In the meanwhile, London Counsel for the petitioner shall be at liberty to file an affidavit verifying the averments made in the writ petition in accordance with that.
Obliged. Item 45.
So item 45 minutes. Initially I was the owner of 5 acres of land in different plots. Minutes. What happened? Once government acquired 1.180 acres, paid compensation. Thereafter, the government for the purpose of laying the rail line, Balangi rail line, they required further area. They have also taken it, and the railway also constructed this without paying any compensation for that. Secondly, what happened? This is a Gharwadi land, household land. Now the rail line is going on, so I don't have an access to that. My request, you take it the total or give me an access. Otherwise, I am unable to use it. There is no other side access, my lords. These are all agricultural and other tapping land. These are all that hilltop areas and all this. There cannot be an access from that side. This is the only access. Kind of a glance to that. I enclosed the map. Kind of a glance to that map. That is at page 13. My plot is 1479 RT. I have written that RT. In that front there is a road. This road we are using. Now rail line, my lords, a portion of 1479, they have undertaken construction. So rail line is going over that area. No access to the entry to that area, plot plans, rest of the plot plans.
No, but this is a land acquisition matter.
This is a land acquisition matter. So
you are seeking payment of compensation.
I am seeking payment of compensation in respect of 1 acre. Some odd miners they have taken it, they have not paid it. Secondly, my lords, what they have done is they have acquired a portion of the Gharwadi land, means household land.
Who are you?
I am the owner of the land.
People's Forum Foundation Trust.
I am the owner of the land.
Huh?
Yes, I am the owner of the land. But kindly have glance to Annexure 1. That is the record of right. This is the record of right. But I am the owner of the land.
And what do they say? The state opposite parties?
I have not received any
counter affidavit has not been filed, but what is his allegation is that railway authority is to acquire that land, and that railway authority is the requisitioning authority. And if they acquire the land, then only payment of compensation would arise.
Right.
So whether the land has been acquired?
No, that is not acquired. They say that it should be acquired by the railway authority. Your lordship may issue notice to the railway authority.
But with due humility, kindly have glance to Annexure 2. That is
the council whether any land has been acquired.
Yes, my lords. All land acquired, construction made, and I have given that acquisition in Annexure 2.
So who has acquired the land?
It's the government, state government. On the order of the governor, one Kailash Chandra Sahu, Joint Secretary, Revenue Department.
So why is the matter pending for last 11 years?
But that is, I filed immediately in 2013, my lords. So let us not speak, my lords, about all this. We tried. Let us
It's not listed yet, I think.
No, notice issued, postal liquidate filed. All these things, the notice was issued way back in 15/3/2013.
And railway authority is to be noticed. Opposite part number 3, East Coast Railways.
We will see. First of all, you file your affidavit.
Yes, ma'am.
It is your notification for the purpose of East Coast Railway. That is a page 11, my lords. Page 10 and 11. In vernacular, of course. I think my learned friend can go through. That is for the purpose of my lord's railway, for the Balangir railway, my lord's railway line. They acquired the railway order to construction. Generally, my lords, the usual my lords, the process is that state government will acquire the land and will hand it over to railway, my lords. My plots are there in page 12.
So it was for the notice was issued in 2013.
My lords.
So that part of the bar.
2012. There are acquisition made in 2013. You have taken over possession in 2013. But you have not paid me compensation. And secondly, my lords, what they have done, they have already taken over possession under to railway, under to construction, they handed it over to railway under to construction. Now rest
My lord, I will take instruction from the concerned land acquisition officer about
This
this
case on 6 weeks. Must let an affidavit be filed. A supplementary affidavit be filed on behalf of the petitioner supporting the pleadings in the writ petition in accordance with the requirement under so and so rule 3. Stop. In the meanwhile, let counter affidavit be filed on behalf of
opposite party 1 and 2.
Opposite parties number 1 and 2.
And Lord, notice may be issued to opposite party number 3.
Who is 3?
Is the East Coast Railway.
We will consider later.
Yes.
I will, my lords, file this affidavit within 10 days, man.
Do it.
Item 46.
May I please, the lordship? In item 46, lordship, may kindly the last order dated 22/1/2024.
Forty-six, here the constitutional validity of a provision is under challenge.
No, I will address, but with regard to your submission on last occasion that you will file the counter affidavit.
Please don't address him.
I beg apology.
In this writ petition, there are 3 writ petitions. In 2 writ petitions, constitutional validity of a provision is under challenge. So I have to file the counter affidavit on behalf of the government. So
What counter affidavit in when the
constitutional validity.
Constitutional validity, how can you can file? This matter is pending since 2013.
My lordship.
What is this matter about? You are challenging to.
This will kindly come to page 44, annexure 5. The relevant portion is page 46, where they have amended section 3B and 7A of the OGLS Act, Odisha Government Land Settlement Act 1962.
Where is that? Page
46, your lordship. The relevant portion is page 46. It starts with page 44, 45.
Yes.
For that, your lordship has to see the pre-amended act, your lordship. I only have the one copy. With much difficulty, I have got one copy of that pre-amended act, your lordship.
Yes, you are aggrieved by which part of the amendment?
The first one is the second proviso.
Second proviso?
Yes, your lordship. Provided further that any land settled prior to the commencement of the Odisha Government Land Settlement Amendment Act 2013, if not used within a period of 3 years from the date of such commencement, the authorized officer shall resume such land. We are agreed by the retroactivity of the amendment, your lordship.
It is not retroactivity.
They are saying that.
Just a minute.
I beg apology.
us see, how do you say that it has retroactive operation? Please read it again.
Provided further that any land settled prior to the commencement of the Odisha Government Land Settlement Amendment Act 2013, if not used within a period of 3 years from the date of such commencement, the authorized.
Such commencement means from 2013.
Yes, Your Lordship.
So what is wrong in it?
No, what they're trying to do is, suppose the land has been settled in my favor prior to 2013. They're opening up such cases after this amendment act came to force that you have not utilized such land for 3 years.
Not before 2013. But if you are not using your land 3 years after this amendment in 2013, then they can resume.
Yes.
So how do you say that it has retroactive?
Saying that, Your Lordship, then I have no case. Let them say that.
No, this is the language.
That may be the language.
Why will they say? We have to say.
Yes, Your Lordship.
We are considering.
Of course, Your Lordship.
What is used is within a period of 3 years.
Within a period of 3 years from
Yes.
such commencement.
Yes.
Commencement of Odisha Government Land Settlement Amendment Act 2013.
13 November 2013.
Yes. Yes. So it has no adverse effect.
Yes, Your Lordship.
Yes, Mr.
Yes.
You don't have any in the present writ application. The petitioner seeks to question the validity of the second proviso to subsection 3 of section 3 of the Odisha Government Land Settlement bracketed Amendment Act 2013. Are we correct?
3B, Your Lordship. It's 3B.
Oh, just a minute. B. No. To question the validity of section 3 of the Odisha Government Land Settlement Amendment Act 2013, whereby section 3B has been substituted as under 3B को the petitioner's grievance is confined to the second proviso in the amended section 3B, which states that if any land settled prior to commencement of the Amendment Act 2013, Act, this is Act of which Act? No.
Odisha Government Land Settlement Act.
Odisha Act 26 of 2013. यहाँ पे Act लिखा है ना? वो bracket में लिखा होगा. Odisha Act 26 of 2013. क्या बोलो? Three B of Odisha Act.
If any land is not used within period of 3 years from the date of such commencement of the act, comma, the authorized officer shall resume such land. Or stop. Next. It is submission on behalf of the petitioner that the second proviso to amended section 3B is ultra vires as it has a retroactive operation. So stop. Next, we do not find any force in the said submission. So stop. It is clear on plain reading of the second proviso of the amended section 3B that the authorized officer is required to resume a land settled prior to commencement of the Act, so as Odisha Act 26 of 2013, if not used within a period of 3 years from the date of commencement of the Act, that is, what is the date?
13/11/2013.
30/11/2023.
13/1.
13/11/2023. So stop. Next.
I may be pardoned to intervene, Your Lordship, for a moment, Your Lordship. Your Lordship, I am the petitioner in the second connected writ petition, Your Lordship. Your Lordship, my learned senior SP Mishra is not well today. Your Lordship, he has to argue on this matter because, Your Lordship, on the point of retrospective, Your Lordship, the provisions 7A3, Your Lordship, original provision. As per original provision 7A3, Your Lordship, provided further that no, Your Lordship, I am just apprising Your Lordship that it should not, no proceeding under this subsection shall be initiated after expiry of 14 years from the date of the order, Your Lordship. So now, Your Lordship, this read with section 3B, Your Lordship, what now they are trying to do is, Your Lordship, they will be opening all the old cases, Your Lordship, which they cannot do because under old section 7A, after the expiration of 14 years, right has been accrued. Now they cannot reopen those cases. But because of this amendment, now they will try to reopen. Therefore, Your Lordship, these writ petitions are filed and my learned senior has to argue on this point, Your Lordship. So,
all right. Got the note. So you should have mentioned that in the very beginning.
Your Lordship, I thought Your Lordship is just recording submission of my learned brother, Your Lordship. I'm sorry, Your Lordship. That's why I didn't intervene, Your Lordship.
Also validity is under challenge.
Your Lordship.
No, he has two cases. In the second matter, my Lord, may kindly see the prayer is for early disposal of the objection petition. That is the prayer.
So you have not challenged the validity.
In the third case, he has challenged.
Your Lordship.
In the third case.
There are two cases with Rashmi kind permission. In one of such cases, he had challenged the virus. The other one, he has prayed for the disposal of the objection case. In my case, where my associate is appearing, in this case, we have challenged the virus. We have also challenged the action of the authority in that 3 years, that period we have challenged. And in fact, what has happened in this case, way back, I have enclosed those documents. 3B was invoked under the old act. And after the due inquiry, after following due procedure of law, and it was said that it cannot be invoked, that 3B cannot be invoked, that was released because it has been used for the agriculture purpose for which the lease was granted. That is the finding. Then after that, they have made this amendment. And by virtue of this amendment, they want to reopen the whole things.
All right, we will hear.
Yes, yes.
But come well prepared.
Yes, sir. Yes, because it's a virus of the matter. We must.
When do you want?
Weeks after.
After 1 week.
Convenient, yes. Only thing is they have not filed the counter till date. If you also.
Counter is not required.
Yes.
If that is the only thing which you are
That is the only-
challenging, then all of you should confine to that.
Yes, yes.
The virus.
Yes.
As jointly requested on behalf of the parties, list these matters. There are 3 matters.
3 minutes.
List this matter on these matters with these matters on 2 weeks.
Item 47.
Item 47, Your Lordship, I request for a short adjournment, Your Lordship. My learned senior is not well today, Your Lordship.
All right.
Any date
As
next week. Your
requested, 2 weeks.
48.
It's 2 weeks adjournment, Lords. I'm proxy counsel. The council is unwell and reeling under some health issues. So in the meantime, the supplementary affidavit and Lordship may direct for filing of counter affidavit.
So first of all, you file. We will see.
Counter affidavit to file.
This is 2015 matter.
15 matter counter.
Counter affidavit may not be required to be filed.
That's it.
Matter can be decided on the basis of your pleadings.
I have received the counter comment. I'll file by.
Do it.
But
Is this matter on 3 weeks? Stop late. Learned counsel for the petitioner undertakes to file a supplementary affidavit duly verifying the pleadings in the writ petition in accordance with so and so.
Item 49.
I have no instruction in this matter. Matter may be disposed of as withdrawn.
Disposed of, withdrawn.
Item 50.
Memo. Withdraw.
Item 51.
Paper tools are time loads.
Five.
Unfortunately, I missed the file. Unfortunately, I missed the file in court.
All right.
Except the interim order is there, Lords.
Interim order on the basis of you forgetting to bring the brief.
Yes.
On this ground.
No, Lords.
As requested on behalf of the petitioner, list this matter on 2 weeks. Stop. It is made clear that the interim order shall continue in the meanwhile. Stop. It is also made clear that this court will not grant further adjournment at the behest of the petitioner, considering the fact that he is enjoying the benefit of an interim order.
Item number 52.
52, my lord, I am for the opposite party number 5. Matter has become infructuous because in the meantime, work order issued in favor of the opposite party number 5, which is also complete, and payment has already been made to this opposite party.
There is no representation on behalf of the petitioner. Learned counsel representing the
Opposite party number 5.
opposite party number 5 informs this court that this writ application has become infructuous as much as the work which is subject matter of dispute in the present writ application has been completed.
Yes.
And payments have also been made. Stop. Next, as there is no representation on behalf of the petitioner, considering the submission made by Land Council for OP number 5, this application is dismissed.
Item 53.
53, my lords, in both the matters, I'll file the improvised affidavit, my lords. And my lords, another difficulty I have, my lords, in this matter, I was being led by Mr. Asim Amitabh Das, my lords. Now he's a member of Human Rights Commission.
Let's I'll reconstruct the file also within a week, my lords. I will need only 10 days time, my lords, to reconstruct the file and to file the affidavit. In the first matter, my lords, there is no interim order. In the second matter, there is an interim order.
Let's here the problem would be that these are against port dues. They are enjoying the lease but not paying the revised rates. Their prayer in the writ petition itself may be contrary to the renewal clause in the lease. So all that let it be adjourned today, but a short date may be fixed. We are giving connected matters. The same issue is pending before this court.
How many?
We
There
are
are
giving the list.
6 matters.
And there are other councils. I think Mr. He knows that there are other councils who are also leading him, all seniors. So it can be disposed of. This is something which is plaguing our revenue at this moment. And there was an earlier round of litigation where they agreed to pay these dues. Now
So
they're
give us-
enjoying the renewal.
Give us a definite date when we can hear all of you and decide it.
Any date, since he wants time, maybe next week if that's convenient.
When do you want? It's in the first week of March, my lords.
As your lordship, please.
No, you also.
I was praying for a shorter date. Then
All the matters I have to file improvised affidavit. First week of. He is right because even otherwise today is what 13th.
Yes.
13th. Let it come on 4th. All right. Great.
I've given the list of connected videos.
We are adjourning the matter for 4th. All these matters shall be taken up at 2:50. What is the time? 2. 2. Take up the matter at 2. All right. We will hear and in the meanwhile, if possible, all of you can give your written notes also.
Short
That will expedite the disposal.
We are all great.
As jointly requested on behalf of the parties, list this matter on 4/3/2024 to be taken up at 2 p.m. along with Stop. It has been stated at the bar that other matters also, that the rest of the matters also involve the same issue, which is involved in the present cases. In these cases, the interim order operating in WPC 8215 of 2018 shall continue in the meanwhile. Great.
I am appearing for the opinion number 1 and 2, this Union of Ministry of Shipping as well as the Tariff Authority of India. In some cases we filed counter, some cases we didn't file. Either we will adopt it or
As you wish. The court further expects that in the meanwhile, the parties shall file affidavits in conformity with the requirement under so and so as to support their pleadings on record.
Great. Item number 54.
In accordance with so and so. Yes.
I'm an amicus in this matter.
Yes.
This was initiated at the instance of the legal aid regarding the menace of fake doctors. We are filing the regularized affidavit here. We have made it ready since it was originally in the older format. So it can be regularized. We have the affidavits ready right away. We can tender it in court. So here, if my lord wants the previous orders regarding the issues involved, there was a direction in order number 9 dated 27th of January 2023, wherein the court called out a series of issues and they have listed. So if my lord may see the points raised there.
Yes.
And in terms of that, they filed an affidavit, and there was a further direction of this court on by order number 10 dated 22nd of June 2023, wherein the court took note of the state's affidavit and directed them to file a further affidavit. That is order number 10, wherein my lord may see after quoting the affidavit, there were further directions in paragraphs 6 and 7 of that order, order number 10.
Yes.
So I believe that in terms of this, there's no affidavit which has been served on.
I think may not be served. I filed an affidavit on 28th of July 2023. If that affidavit is not with my friend, Lord, I can give it in court. Lord, so also record it. I'm giving it in court. Lord.
And this paragraph 6 also deals with the surveillance mechanism and what they are doing. That is something which they probably have.
Yes, we have explained there. I'm serving a copy on my friend, Lord. Let him go through and may call this matter some other time.
I can apprise your lordship that this issue of this fake doctors is a problem in these tribal belts of Orissa, which would be there in the southern districts of Rayagada, Sundargarh, where these quacks are functioning. The earlier benches, of course, this what they have basically done now is
the quacks is one problem. One problem. The other problem may be that where the persons may be misrepresenting to be qualified doctors, which they are not. So we are dealing with what type? Quacks or
both
fake degrees?
Fake degrees and quacks, both. But the government, I believe, has in the meanwhile, they have taken steps to regulate the existing doctors. But so far as the fake doctors and the quacks, they probably have to initiate proceedings and all, which that was the issue for which this is being kept pending.
So what procedure has been adopted to identify who are the...
In that affidavit, I've explained that all the doctors, those who are serving me, Lord, they were called upon to give their details, and the officer concerned were also directed to collect those data, including their qualification and also registration certificate.
Serving? All the doctors who are serving or what?
Yes, those who have been registered, either serving under the government or doing private practice, whatever it is. All that.
So that has been done?
That has been done. I will give a copy to my learned friend, Amicus Curiae. Let him go through. If he wants anything add, we can also prepare to do that also, as for it. Because it's in the interest of the state and people. I don't have any...
Let him serve the copies. I'll file a convenience.
Just a minute. Just. But this order was passed when? June 2020.
Yes, June 2023.
You have not filed the affidavit?
No, yes, I filed that affidavit, dated 28th of July 2023,
You have filed?
Yes, I filed it through e-filing. If I also do it, I can give the date, on 28th itself, 28th of July 2023, it was e-filed,
25th of July? Huh? Let a copy of the affidavit filed on behalf of the opposite party number 2 online on 1/8/2023 on behalf of the state of Odisha be served upon learned senior counsel Mr. Gautam Mishra in course of the day. Today you will serve.
I've given it. Already
In course of the day. Stop. List this matter on 2 weeks, Mr. On 2 weeks. So stop. 2 weeks so as to enable Mr. Mishra, learned, Mr. Mishra, learned amicus curiae to go through the said affidavit so as to effectively assist this court in the present matter in the nature of public interest litigation.
And my lord, on behalf of Mr. Arsimad, my lord, we are appealing to opposite party number 2, my lord.
Who is 2?
Medical Council of India.
So what do you want?
A copy be served on. A copy of the affidavit also served on us.
Is he not your friend?
Yes, yes.
Then take that favor.
But in fact, DMT is with us only, not. It's a creation of the state government only. I can give a copy to my friend because everything.
No, he is Medical Council of India. He is not creation of your.
Medical Council of India. Then I can, because he also appears for DMT also, not. That's why I'm saying that.
My lord, I am in virtual. My lord, I am in virtual. I am suffering from fever. That's why I couldn't attend the court. I am for National Medical Commission and also for the DMT.
So there is no Medical Council of India.
No, it is National Medical Commission, my lord.
Originally, it was Medical Council of India.
Medical Council of India. Now it is National Medical Commission.
Right. So you are representing whom?
National Medical Commission.
National Medical Commission. So why
Yes,
is he representing?
Who, my lord, who?
I think my
He's my associate. I was, I am
on
sick.
behalf of Mr. Mahanti, my friend, my Mr. He's area for LGBT and others. Government of India, National Commission of India, we are appearing. And they are appearing for the state whose agency is there.
He's saying he's appearing for the National Commission.
It's wrongly submitted. It is
No, my lord, I have filed my power.
Earlier there is a appearance of some cases, Mr. Mahanti. Now it was turned down and they have been.
No, my lord, I have filed my Uklatnama for NMC in this case. There is no controversy in that. Because I am not well, I couldn't attend the court today. That's why, my lord,
No, you are attending the court. Despite the fact that you are not well, you are attending the court online.
Yes,
there
my
is no difficulty.
Yes, my lord.
Are we required to decide this dispute as to who will appear for the national?
No, my lord. No, my lord. I am from
Please,
the beginning.
or the next day we will consider.
Yes.
In the meanwhile, you resolve it.
Yes, I'll take a clarification also. If they want to appear, they
Please, it is very embarrassing for this court to face such situation.
I don't know how my senior is telling like that. I don't know, my lord.
We will see on the next day.
Yes, my lord.
We will. The proper format of the affidavit we have tendered in court.
All right.
We are all grateful. We are all grateful for this.
Item 55.
May I please, your lordship. We are challenging the order of Honorable Single Judge Miller granting provisional pension. I am appearing for the bank. Appellant is the bank. Granting provisional pension to the respondent number 1. My last time, Millard, it was argued, I have raised 2 questions, Millard. One, the pension regulation is not applicable to the respondent number 1 and is not eligible to get even pension. The question of getting provisional pension will not arise. Second question, Millard, that when he was in service, a departmental proceeding was initiated for very serious charges. And in the meanwhile, he has superannuated and the proceeding continued in view of the regulation that 45(2). And the specific provision is till the proceeding is completed,
is not entitled for any retirement and other benefits. My lord, I have given some dates, only 4 or 5 dates are relevant. My lord,
Please.
30/12/2014. When he was in service, my lord, a proceeding was initiated for serious charges and misappropriation. And even, my lord, the customers, who have deposited the amount, diverted to other accounts. And my lord, for that proceeding, that is annexed that page 35 to 39 charge sheet is there. While my lord, the proceeding, the charge sheet, he has filed a writ application at the stage of charge sheet, my lord, issue of charge sheet, that writ application 16810/2015. That is pending. After filing the writ application.
No, whether the departmental proceeding is over.
No, pending. My lord, that is, I have given that 6/10/2015. Challenging the charge sheet, he filed a writ application. This with a interim application. This honorable court permitted the bank to proceed with the inquiry and no final order be passed. Thereafter, my lord, the inquiry was completed in 2016. Because we are filing memos for permitting the bank to pass final order, my lord, somehow the matter was not.
No, but for whatever reason, the
That is
departmental
pending.
proceeding
Now,
remained pending.
Pending. That is admitted position. I am saying one not disputed matter. Thereafter, my lord, while it was pending, we are
So
superannuated.
that interim order was passed in the writ proceeding.
No, my lord, your lordships, without liberty of this honorable court, we are prohibited to pass any order.
No, passed in this proceeding or in the writ proceeding?
Yes, disciplinary proceeding.
In a altogether separate writ proceeding.
No, I will let me make mistake. My lord, your lordship 6/10/2015. That order was quoted. As an interim measure, the disciplinary proceeding initiated against the petitioner.
So when was that order passed?
That is 6/10/2015.
Right.
And the proceeding, my lord, thereafter Sokaji has filed, second Sokaji is given. And
So when was that writ petition disposed of?
Not disposed of, that is pending in view of the order passed by this honorable court. This honorable court has directed the bank, before passing final order, liberty with.
So that writ petition is still pending.
Still pending.
So that writ petition will have to be decided.
Yes.
Either it should preferably be decided before.
That also I will come, my lord. After giving the 3 dates, I will come to that point. In the meanwhile, my lord, 2017, he has superannuated from service. Pension regulations, my lord. Earlier, pension scheme was there. 1995 pension scheme was there. In lieu of that pension, now pension regulations were published in 2018. That is 12/12/2018. There, my lord, section that applicability and eligibility of the pension provision were there. Those who have retired, they have to, my lord, return the contribution made by the bank within 120 days. They must opt for the coming to the pension scheme within 120 days and refund the amount which was contributed by the bank to the EPF within 60 days from that. And he has opted to come to the pension regulation, but has not returned till the filing of the writ application. When that has come to my lord, he has filed second writ application on 7/8/2019 with a prayer to release to grant the pension and other retirement benefits. That is, my lord, WPC 1365 of 2019. That is second. And pension regulations came into force the 12/12/2018. Now, my submission, first submission here, my lord,
because he has not fulfilled the condition laid in the pension regulation. He has not come to the fold of pension regulations. Milord, Your Lordship, I have given the pension regulation. First, Milord, Your Lordship, page 101.
Page 101.
Page 101. Annexure 5. Your Lordship got it.
Yes.
Milord, Your Lordship, kindly see at page 103.
I have compiled the document, Your Lordship.
Let me make my submission. Why you always?
Just a minute, just a minute, just a minute.
I have formulated the point.
Just a minute, Milord. We are passing over the regulation for convenience. What is the objection by my friend? I do not understand.
Please.
I have compiled the documents, Your Lordship can see from there.
All right, we'll see.
I have formulated the point. Matter was argued before him. That Milord, Your Lordship, kindly come to
Argued before
page
him?
103.
All right. Please.
That is applicability and eligibility of the pension, Milord.
Yes.
Milord, Class C, Your Lordship, kindly see.
Clause C of what?
Pension regulation, chapter 2, applicability and eligibility, regulation 3, page 103, my lord.
Yes.
These regulations shall apply to any employee who say A, B not applicable, C is applicable, that is admitted position, was in service of the bank on or after the first day of September 1987, who continue to be in service of the bank on or after the notified date and in exercise an option in writing within 120 days and the notified date to become member of the fund and cause to transfer the entire contribution of the bank along with the interest accrued thereon to the credit of the fund of constitution and store. So time is fixed. So he has, Milord, according to the pleadings, he has opted for to come to the pension fold. But that amount is not refunded till filing of the writ application. Milord. Now, Your Lordship, kindly see next page, clause 2. Page 104, clause 2, Milord. An employee or family of the deceased employee not exercising the option under sub-regulation 1 or who after exercising the option not refunding the amount shall be deemed not interested to become the member of the fund and shall continue to be governed under the employee pension scheme. That is existing scheme. So it is a deeming provision and very clear, Milord. He has not refunded. Now, Your Lordship, kindly some the writ application filed by him is admitted all these points, Milord. That is also available with Your Lordship. Pleading, I will what ground he has taken in the writ application 13965. Each prayer in the writ application as if normally retired from the service, he filed to release the pension and other retirement benefits. Though in the writ application, Milord, prayer I am placing, Milord, annexure, Milord, that writ application 13965 of 2019.
That has been scanned. Scan copy is there. Yes. Of the writ petition. But it is not there in the brief.
Yes, it's there.
It is there in the brief.
Milord, before that prayer I have placed, Milord,
It is therefore humbly prayed that the Honorable Court be graciously pleased to admit the writ petition, issue notice to the opposite parties, and after hearing the parties, allow the writ petition.
Just a minute.
Yes.
Which item is this? 55. 55.
Yes, at least it was.
You are referring to what?
Prayer, Millard, page 7.
Okay. Where is that?
Page 7 of the writ application.
Hmm?
From here I'm okay.
Okay. Yes.
Writ petition direct the opposite parties to release the pension and other retirement benefits forthwith and pass such other orders, so on, so on. So this is the prayer, Millard. Now come to the pleading, Millard, paragraph 5, we have admitted about the pendency of the writ application. Paragraph 5, page 4 of the writ application. Last last, Millard. The charge against this petitioner filed WPC number 16810 of 2015 was pending for adjudication.
You are reading paragraph 5.
Paragraph 5, page 4 of the writ application.
Yes, pertinent to a state.
Last, Millard, that paragraph 5, last 3 lines, fabricated charges and which the petitioner filed writ application 16810 2015, which is pending for adjudication. Only to point out, Millard, admitted fact, by the time the applied for the pension, the writ application is pending after retirement, which is under regulation 45(2), allowed the authority to continue the proceeding till it's take finality, and till then he is not entitled for any retirement and other benefits. That, Millard, there are number of decisions also on that, Millard. Your Lordship also, this court decisions also. I'm coming to the only pointing out to your Lordship, the writ application disciplinary proceeding is pending by the time he filed this application for the purpose of pension, release of pension. Second, Millard, he is also aware, next page, page 5, para 8, he referred that section 3C, which I have placed before Lordship, that pension regulation 2018. A part of the regulation is placed, and the relevant portion where he has to opt for within 120 days and deposit the amount within 60 days from that completion of the 20
So he
days.
had not complied with that
He is
requirement.
not complied, Millard. That is, Millard.
So till that has not been complied with.
That is not by the filing of this Millard writ application not complied. And this honorable court at this position, Millard, directed to release the provisional pension by the honorable single judge, directed to release the pension, provisional pension with 7% interest. That is under challenge before your Lordship now. Millard, your Lordship, I kindly see ground number G. There I have specifically stated Millard, the writ appeal, your Lordship will get it page 13.
Yes.
Ground number G, last ground. Millard, sorry, page 12, ground number F, Millard. Page 12. Last 2 lines start ground number F. For that honorable single judge, in the impugned order dated 17/12/2019, directed for release of the provisional pension along interest of 7% per annum, although in favor of petitioner, which is very much illegal in view of the Regulation 3, Regulation 32, Regulation 50, Orissa Gramya Bank Regulation, that is which I have placed Miller, Pension Regulation 2018. In as much as it is obligatory on the part of the employee who wants to avail bank pension shall have to firstly submit an option to avail the bank pension. That is within time he has applied, within 120 days. Pension fund in lieu of pension from employees pension scheme 1995 under EPFO, and secondly, second condition is not complete. Secondly, apply for the pension by refunding the entire amount of the bank's contribution to the employees pension scheme 1995 with interest accrued therefrom. That is not complied with.
Yes.
I have read Miller's rule, Regulation 3C, specific cut-off date is there. Regulation 3.2 says that unless he complies it, it deems he is not interested to come to the pension regulation. And earlier, the pension.
It's a very simple point.
Yes,
according to you,
yes,
even if he was entitled to pension and he was not to be treated as this thing,
employee,
despite pendency of the proceeding, departmental proceeding, since he had superannuated and was in service, he is not entitled to any pensionary benefit under that regulation because he had not complied with that requirement of refund of.
Yes,
This is a simple point.
Yes. And that is very specific Miller condition that unless he comply that, he deemed to continue in the old pension rules.
Yes.
1995. So this is one ground I have taken Miller. Second ground I have taken Miller, that under service regulations, Regulation 45.2, that if a proceeding was initiated while he was in service, after superannuation, it will continue till the proceeding is completed. Till then, he is not entitled for any pensionary or any retirement or other benefits. He will only receive each portion of the contribution to the CPF. Nothing else he is entitled.
Where is that?
That Millard, your lordship kindly see, that is I have annexed.
And he will not be entitled to even provisional pension or anything.
Yes. That is Millard similar to in banks also. That is Regulation 20, Sub-Regulation 3, and provides similar Millard parameters, same language. There, this honorable court, a case has gone from this honorable court to the Supreme Court in Mahanadi Coalfield, and that was interpreted. Once the proceeding was initiated, till it is finality, he is not entitled to receive the benefits, retirement benefits. And Millard, that relying on the some decision, that is a gratuity matter, and matter went to the Supreme Court taken by the Mahanadi Coalfield. Since there is a conflict of decisions, Millard, the matter was referred to 3 judges bench. And the gratuity was not released because the proceeding was pending. It is premature. On that ground, they have rejected. This honorable court relying on Supreme Court decision of Mahanadi Coalfield, that is 1900. They say it is being directed to pay the gratuity. That matter was taken to the Supreme Court. Supreme Court has referred the matter to the larger bench to decide whether it is entitled to get the gratuity, and second, whether a punishment of dismissal can be passed. That was answered, Millard. At paragraph 11, I will please give copies to you.
Supreme Court has said that even after the bank employees, that order of dismissal can be passed even after retirement.
Retirement.
That is
And,
peculiar.
Till the disposal of the proceeding is not entitled for any gratuity. Two findings are given. Milord, that your lordship kindly see page 83 of the brief. Page 83 of the brief.
Page 83 of the brief.
Milord. Right, of course.
83 is what?
83, Milord, your lordship, last regulation 45. Disciplinary proceeding after retirement. Lordship got it. And next page, Milord, sub-regulation 4.
Annexure 4.
Sub 84, page 84.
Just a minute.
The op.
4. Annexure 4 to this, that is the supplementary affidavit or what?
No, Milord, that is
Writ appeal.
Writ appeal, page 83 and 84. Page 83, Milord, that is regulation 45, service regulation.
Just a minute.
It starts from, Milord, annexure 4, page 55.
Just a minute. Just a minute, Mr. Annexure 4, yes.
Annexure 4 starts from page 55. Regulation 45, sub-regulation 4. Milord, your lordship will get it. Page 83 and 84.
Regulation 45.
45. Sub-regulation 4.
Yes.
At page 84. The officer or employee against whom disciplinary proceeding has been initiated shall not receive any pay and or allowances after the date of superannuation, and also not be entitled for the payment of retirement benefits till the proceeding is completed and final order is passed thereon, except his own contribution to contributory provident fund. Explanation. For the purpose of this regulation, the normal retirement benefits such as encashment of privilege, leave and gratuity may be withheld till the completion of the disciplinary proceeding. Lordship, kindly see the impugned that now I am come to the judgment, Annexure 1. Annexure 1. Judgment page 19, but order is 17/12/2019 at page 21. My submission here, Milord, challenge the writ application in the writ appeal, 2 grounds. One, Milord, because he has not come to the fold of regulation as I place. Question of is not entitled for pension. Question of granting provisional pension he also does not arise. And the pleadings I have placed, that is prayer only to release the pension and other benefits basing on regulation 13 and 3. So regulation, he has not challenged the regulation. On the basis of regulation, Milord, regulation 3 says, because he has completed 10 years of service, he is entitled for the pensionary benefit, so be released with that prayer he has filed. Noting regulation 3, Milord. Now your lordship kindly see the last portion of the order. He has quoted Milord and single judge has quoted this provision. It was taken this provision and both the provisions The pension regulation 45(4) also is taken note of. And we have paid before the Honorable Court to take both the matters analogously to decide so that the matter can be set at rest. But Honorable Single Judge Miller only disposed of this pension writ application, giving liberty to me to move the concerned court for listing that case. That also I have taken ground in the writ appeal, Miller. Now,
Is that all, Mr.
yes, that is two grounds, Miller. One, this regulation, the pension regulation is not applicable. Second, in view of regulation 45, sub-regulation 4, till the finalization, he only entitled CPF. And Miller, one more thing, Miller, your lordship kindly see page 35. What he has done, Miller, customers, when the customers have gone to him.
No, we will not go into that. You are.
No, that is relevant, Miller, for the purpose. Miller, so if in case, in the disciplinary proceeding, he was likely, in view of the facts, he is likely to be dismissed.
No, we will not go into that. Sorry, Mr.
Miller,
We will not go into the merits of the allegations against him in the departmental proceeding. Sorry, we will not.
It is also taken note by the Honorable Single Judge in the judgment.
All right, we will.
And no, only I have annexed it to along with the counter play filed in that case. There the charges have pointed out 63 instances of public authority.
That is entirely different. That we should not comment upon.
This is the 2 points, Miller, legal points. And he has not come to the fold of the pension. So question of granting provisional pension does not arise. The second, in view of the service regulation 45, sub-regulation 4, that is only till the disposal is only entitled each contribution so the Miller. That is it. Now what your lordship kindly see, we have filed now he is getting pension from 2019. He is continuing to enter. Your lordship also, when in the writ appeal, the interest portion you have granted relief, but your lordship directed to go on paying the pension. We are trying to get the civil criminal disciplinary proceeding matter elaborately, Miller, at every stage, at every possible.
What is the case number of that?
16810
of
2015.
2015.
And the proceedings were completed as allowed by the Honorable Court.
Yeah. 16810 of 2015 records.
Where the proceeding was completed as allowed by your lordship, Miller, in 2016.
We understand, Mr.
It's 2016 itself.
We have registered.
Yes.
That has been registered in our mind that because of some interim order passed.
That is the only point. I'm not going to the other facts.
As I understand, the law, the bank is happening.
No, he has taken only 2 points.
I am coming to that. Bank is happening on 2 points. In fact, bank is happening on 3 points that I will bring to your lordship to show the conduct of the bank later. But let me first meet the bulls by its ornament. So it is happening on the point that regulation 45, 4 of the service regulations. That is one, that during a proceeding, the pending departmental proceeding is not entitled to anything. Then he is stating that he has not come into the fold of this pension regulation 2018, and therefore question of granting him anything under that provision doesn't arise. The two are diametrically opposite stands. If I come,
what is your stand?
My stand is that I am squarely covered by 2018, and since it is a specific to pension and the provisional pension, the service regulation, so far as contributory is concerned, that will be excluded from this. Because that is a general provision. This is a specific provision. The only objection the bank seems to have is that I have exercised my option, but has not deposited the amount I have received from the bank. That is in order to
Will that amount to the exercising the option without refunding the fund?
That's right. I am coming to that, my lord. Lord, for a minute before my submission, my lord, may I take your lordship to page 209, my lord?
This is what? It's already there, sir.
Yes.
There before me.
The 200, sorry, my lord, not 209, that is begins from. But there is no dispute that I exercise the option. Then the next step is that I should have refunded the amount. There are 205, your lordship has 202, yes, 202 also, 205. Your lordship may kindly see that I have given 202 annexure F series below to my counter below. Running page 202. Has your lordship got it?
Just a minute, just. Annexure F.
Annexure F series below.
Yes. Yes.
202, my lord. Showing your lordship why I am placing it, my lord.
Annexure F is there before me. It is at page 202.
If your lordship has gone, through that regular scheme, my lord, regulation, pension regulation, section 3, C2, where it says that along with interest, I have to refund whatever I have received from the bank. That presupposes a calculation. Otherwise, how much is the bank's dues? How will I know it? So, after exercising the option, page 202 onwards are certain sample letters that has been sent to different retired employees. And heading is sanction of superannuation pension. Has your lordship got it?
We have
Page 202.
Paging is not there. Annexure. Annexure F series is
I
there.
have given page mark, my lord, 2 copies for convenience. That is why my learned friend took objects. We have compiled the documents and I passed over 2 copies to the court master for convenience of this court.
Yes.
May I?
1, 2.
Good. Has your lordship got it?
Yes, this is not paginated. I don't know why. This page is there. Why is it not paginated?
I have paginated my copies. I have given.
So whether your pagination matches with the pagination which learned counsel is having.
I have not given copy to him.
Please give him a copy.
This copy is not given.
This copy is not paginated. We have given a compiled.
You are making reference. How can
Please,
I know?
please, I'll take care of your inconvenience also.
When I talk of convenience, you object.
No.
And then you say that how can I?
No. Plus, just a minute. You are referring to a page.
Page 2.
So how will he know that you are referring to this page?
I'm handicapped. But I wanted to give to all for convenience, but as if I am disturbing him, I objected.
All right. Let us.
202 has your lordship got it?
Yes.
When the last portion, your lordship will kindly say. General manager, HRD, button. Copy to branch manager, whose I answer is advised to inform the member to deposit rupees 50 to 5,24,278 in current account number of towards bank share in EPF and to execute an undertaking to refund the differential amount over and above the amount deposited. This sort of letter has been issued to many employees, but it was never issued to me. So I was not I exercised the option. My name finds place in the list of eligible employees to get the pension. That document is there. And then this was not given to me at any point of time.
So this objection must have been raised by the bank in the writ proceeding that you did not refund the amount.
Writ petition that no objection was raised, madam. It was only when
in the writ proceeding whether any objection was raised on behalf of the bank.
In the counter there was nothing.
On the behalf of the bank that you are not entitled to pension also because you did not make refund of the GPF amount.
Well, at page 26, my lord, is the counter affidavit filed by the bank, my lord.
No, all right, we will see the counter affidavit later, but tell us whether this stand was taken.
But I have not verified, but I have verified. They have not raised. I have instructed, my lord, that's why when I make a statement, I must be 100% sure.
We understand. So this plea was not taken.
This plea was not taken. It was only when the question of provisional pension came that the court directed that you are not giving him the letter. On the background, we submitted that we didn't receive. So we have not deposited and we are ready. And
no, did you take this stand that you could not deposit the amount because you were not given the
when they raised this question.
Just Lord Senior Counsel, it appears, has not been properly instructed.
No.
Right.
Well,
we know the responsibility with which the counsel of your stature addressed the court, and we are very happy the way you have addressed and better get further instructions from your from the judge.
I am telling you, when they raised this question for the first time in this court, that were not. They all along have in the writ application that 45.
No, there are two aspects. When you say that you had opted for the pension scheme, then you must also have taken a plea that I am also entitled because I have complied with all the requirements. Otherwise, you would have taken this stand that see, I opted and they were required to furnish the statement of account for refund of the amount, which was not done. Therefore, I could not comply with. So this is a. So you please, instead of having consultation here, Mr. You can.
But we came to the court when others received the pension and we didn't receive the pension. And for the first time, they told that you have to refund. When we told that where is the calculation, then the court directed that all right, you first deposit to prove your bona fide. I have got backed by decision, that it will not amount to a waiver. Even if because it is a beneficial legislation, that will not, I will not be stopped from receiving the pensions once I comply with it. Because there is a provision of payment of interest in that section. Area along with the refunded amount along with the interest. So I deposited. Thereafter, the court directed for grant of provisional pension, because under the definition of pension, 45(4) says that pension and retirement benefit. under the definition of pension as given in the pension regulation, pension stands under altogether a different heading, and provision for pension stands in a completely separate provision itself with the regulation. So it excludes provisional pension. And the Honorable Court has not directed that you grant him provisional pension. Even when your Lordship admitted this writ application, your Lordship going through it or told that all right, you give them from prospective from today onwards, don't pay arrear, don't grant interest till finalization. You pay provisional pension to the employee. They, without seeking a modification of that order, they stopped, they gave for some time, then stopped payment of the provisional pension in blatant disregard of this Honorable Court's order in passing writ application. And the stand they took is that.
No, but
I am telling you, Lord, I told your Lordship there is a catch of third point. The stand they took when I filed an interim application, they took a stand that I have incurred a loan from the cooperative society, and that loan has to be recovered, and that is why they have attached this provisional pension. 2/3 they have attached and 1/3 they have given. But this is it.
no, but should it not be proper that this writ application is decided immediately as soon as it is possible?
Well, the already date has been fixed for hearing of that writ application.
When?
He knows, Lord. He had argued that Lord. My Lord, senior was there, Lord. He had mentioned me before the Honorable Court, Lord.
So when is the date fixed?
Mahapatram, Lord.
When is the date fixed?
He had pleased that only, Lord.
Do you have any idea?
He knows, Lord. He was
Week after.
Huh?
Week after means that has not come up thereafter. We
A week after.
Memo also filed for listing that. Memo filed for
A week, court has directed to list matter a week after.
that.
When?
Millard, sorry, posted in the month of March. We have filed an IA.
This order was passed on 9/1/2024. List this matter in the next week in the weekly list.
Yes.
What happened in the next week?
No, it has not been listed.
Someone is saying that it has been fixed in March.
No. We commencing, that is the order, Millard.
This is the order.
Yes. That is, thereafter the matter was not listed.
But how are you saying that it has been fixed on some date in March?
See.
When the matter was moved again, memo was filed, you move it in the month of March. That's what.
We?
To move in the month of March for listing. That was the deputy director.
Memory.
Court has again, the matter was mentioned when the matter was not listed. Then court
orally observed
liberty to move mention in the month of March.
All right, please give the late announcement.
I have no objection if your Lordship.
No, how can you have any objection?
Fixes it to be heard at any point of time. But I only think what I say.
Sir, it is always a privilege to hear senior counsel like you. Mr. Rao also.
Yeah. But I want to make only real suggestion.
Yes.
45/4 speaks of pension.
Yes, we have understood the submissions which have been advanced. We are fixing the matter for further hearing after 2 weeks. All right. In the meanwhile, I'll make an attempt to ensure that writ petition is taken up for final hearing.
Yes.
All right.
All right.
So this is what, yes, brother?
But the provisional pension is also
We will
not being given.
We will see. We will see. This matter has been listed before us after how many? See, you filed, the appeal was filed in 2020.
No, matter was argued made at length, the submission which I have made. Then Honorable Court asked him, the other side, to meet that points, these 2 points which I have raised. Asked, but thereafter the matter, the
All
bench,
right.
bench has.
All right. So the next day when we are sitting together for that change.
Let him go on paying.
Sit together.
Courts are, this is, that should be a zero tolerance of disobedience of the courts are.
File a contempt petition, we will see.
That is also, I am filed an IA in this application, but I am telling an officer of the court, it is also my duty to see. You should see
Correctly.
the dignity of the court is maintained, my lord. Some branch manager cannot play hide and seek with the court.
Learned senior counsel representing the appellant and Odisha Gramya Bank. Odisha Gramya Bank. Stop. List this matter on पोजीशन जजमेंट का है ना, एक जजमेंट का इनके साथ है ना, कौन सा डेट? हाँ, उसी डेट को रखो.
These are only small 2 points, legal points.
Yes. Thank you. Date बताओ.
Fixing that matter.
Fixing date on बताओ.
I'll get it.
Just. No, we will give it. 11th March. And the arguments have been made so effectively that we cannot forget the points on the next date. Yes.
Very small point.
Yes. बट ऐसे भी आना
Item 56.
My lord, I'll wait for 4 weeks time. I'll be region counter already received. Further 4 weeks time.
4 weeks rejoinder and supplementary affidavit also.
Item 57.
Item now 57. Pray for 2 weeks time to file rejoinder.
File rejoinder.
Yes, my lord.
Rejoinder supplementary affidavit.
I have already filed counter for direction.
It has been stated by learned senior counsel representing OP number
Opposite part of 8 and 9.
8 and 9 that counter affidavit has been filed, has already been filed. Therefore, he is seeking rejoinder.
Therefore, he wants to file it. Yes, I have also given a list of compilation.
All right.
The last is not maintainable. Yes.
All right.
58. Item number 58.
Can we take it up next week, my lord?
Next week. As requested on behalf of the petitioner, list this matter on 2 weeks.
Item 59.
59, my lord, I will file the affidavit. I will file the affidavit in terms of.
How much time?
A similar matter, I'm for the opposite party, my lord. The similar matter has already been dismissed by this honorable court. I have the orders also. The same matter, my lord.
Not on merit. Huh?
Not on merit.
On a ground of limitation, my lord. On ground of limitation, my lord. Well, your lordship may just have a clause.
This is a different matter.
Same way, my lord.
File affidavit.
In,
I will place the matter on.
my lord, in this case only, in the impugned order, my lord, the order they have challenged from the honorable the learned tribunal.
So you want us to hear without the counter affidavit or with the counter affidavit?
Just
as you wish.
My lordship just have a glance at similar matter.
I'll see.
My lord.
We will see. So you are representing whom?
I'm for the opposite party, ma'am.
You are for the opposite party.
Now, the state is the petitioner here, challenging the learned tribunal's order. Impugned order is at Annexure 1.
Now, Marun, kindly see page 10. If my friend is submitting, kindly see page 10 for a moment.
What happened in page 10?
Page 10 is the impugned order.
Impugned order they have challenged.
On the very first date, it has been disposed of relying on another order. And we say that it is not covered.
Because the same order has already been affirmed by this Honorable High Court.
On the very
that was the entire submission before the learned tribunal, my lord.
This is not the way of making submissions in a high court.
My lord.
He is making submissions from that side, you from here.
I'm sorry. I'm sorry. I'm sorry.
Let us have mutual respect and some sense of discipline in the court proceedings.
That's right.
2 weeks further time is allowed for the state opposite parties to file counter affidavit. This matter. Huh?
Affidavit in the form. High Court rules for.
Oh, sorry. 2 weeks time allows for the state, for the petitioner to file supplementary affidavit. Supplementary affidavit for verification.
Yes, sir.
Supplementary affidavit verifying. Yes. This case 2 weeks.
Item 60.
The lordship, 2 weeks time may be given to file supplementary affidavit.
2 weeks.
In the meantime, I will also file counter.
And the state shall be at liberty to file counter affidavit in the meanwhile. 2 weeks, 4 weeks.
61.
May I please, your lordship. On behalf of Mr. P.R. Singh, may I be permitted to submit in this matter? Well, this matter, your lordship, the petition is seeking your lordship indulgence to interfere with the order of a compounding the vehicle, your lordship, on the ground that the compounding penalty and the compounding amount is high, your lordship, not proportional to the vehicle was seized for taking my iron ore, your lordship.
Iron ore.
22 metric ton of iron ore. The petitioner applied for compounding of the offence, your lordship. It was allowed, but the amount of which was asked by the authority to deposit is high.
How much?
It's your lordship will see 6 lakhs, 4 lakhs for the your lordship for 4 lakhs is the compounding fees and the penalty is 2 lakhs. The total 6 lakhs has to be paid.
Then,
so my lord, the 22 metric tons of iron ore, that is fines. The value on the last date of hearing your predecessor bench, your lordship, I had filed in documents also regarding the value at that point of time.
Value of what?
A value of the iron ores.
That is not relevant. Value
My
of
lord,
the
my lord, my lord,
of the conveyance.
my lord, the rule says the penalty, because they have
which rule?
Rule, my lord, Orissa Minerals PTS Rule 2007, penalty is in Rule 18.
No, the order has been passed under which provision?
This Orissa Minerals PTS IMR PSTT rules
Which
2007.
provision of that rule?
That is, the penalty is there for in Rule 18. It was compounding is at Rule 16, Your Lordship.
Rule 16.
Rule 16, the compounding. They have the power to compound. At
Rule 16 of?
This Minerals Rules 2007.
2007.
My lord.
Where is that?
The penalty is Rule 18.
Huh?
Penalty is Rule 18. And it is at in consonance with the MMDR Act, while the penalty is in section 21 in the MMDR Act. This rule says 18 says, Lordship got it?
Yes.
Whoever undertakes or causes to undertake the illegal mining, transports or stores many minerals, then with the provisions of section 4.1 and 4.1a of the Act. Act is that is Your Lordship MMDR Act. Implement for a term which may extend to 2 years or with fine, which may extend to 25,000 rupees or with both. So here the penalty is 25,000. And in this order, it has been penalty has been. It is there in this 2007 Rule 8.
Relying upon unamended provision. It has been amended in 2021. Thereafter, the offence has been committed.
And
It is relying upon old
the
provision.
fine is, with the fine, the imprisonment has been added in the fine because it is with the MMDR Act also the penalties, provisions and compounding are there. And a penalty as per the MMDR Act, Your Lordship, section 21, it says that whoever contaminates the provision of section
No, please first come to Rule 16.
My lord. This is on receipt of application from the accused person, the competent authority may in exercise of its power conferred under section subsection 1 of section 23 of the Act. Act means the MMDR Act, Your Lordship. 23A of the Act. It is the MMDR Act.
Yes.
Which says about the compounding.
So your compounding has been done under this provision only?
Compounding in this provision. Because MMDR Act also there is a provision for compounding, and this Orissa Mineral says the
all right, the power which has been exercised under Rule 16 of this 2007 rules.
7 rules.
All right.
Right.
So some order was passed under sub rule 1 of Rule 16.
16.
All right. Now come to sub rule 2.
After the offence is compounded, the accused person is not interested to pay for the property seized, or the competent authority is of the opinion that the such property shall not be released in favor of the accused, he shall not compound the offence and take charge of the seized property and dispose it of the public auction.
Yes.
16.2, Your Lordship.
Yes. Then
I have applied for compounding and I'm ready to take the vehicle.
Take the vehicle, but there is consequence provided under sub rule 2.
No, that is there, but they are allowed. They are allowed. My compounding, my application has been allowed.
Your application was allowed. But in case you do not pay the amount in accordance with sub rule 1, the consequence is provided under sub rule 2.
That time.
So that must have taken effect. The order was passed when?
The order was passed in
September 2021.
September 2021, after the offence is compounded. So it's power exercised under sub rule 1. And the accused person is not interested. You are not interested to pay. The property seized or the competent authority is of the opinion that such property shall not be released. He shall not compound the offence. So he cannot compound the offence.
No, he compounded the offence, but the amount he has asked for me, for which I am for Your Lordship, that the amount which is being charged is exorbitant because
so therefore you don't want the offence to be compounded. That is the only thing.
Now they can, if they will reduce, then
no.
Because the value of the goods as well.
You should face the consequences. This is the provision. Provision is quite clear.
Similar cases, I have a judgment of the parallel High Court in which the same thing, same procedure, same rules. They are also, because there is a discretion power. It is not there is no provision has been set out by the state that how much the compounding fee, how it is to be compounded. So therefore, they are charging compounding fees is in with the discretion of the authority. So therefore, there is a judgment in which that value of the goods has been taken into consideration. Then it has been released on the.
See what is the meaning of this PTSMR PSTT?
That is the prevention of theft. That I admit, your lordship. So that
compounding compounding is at the discretion of the person whose property has been stolen. All right. So therefore, it's very difficult.
So only thing is that because similar judgment, so therefore I was.
Where is the judgment?
I'm saying.
We cannot take up today.
My lord.
No any further matter. Yes, madam.
Your lordships had asked us to mention that nursing matter, item 74.
Yes.
Which all have been listed today.
All have been listed.
Today, the BSc nursing matter.
Yes.
Which is only on the issue of the IM.
My lord, I am for the DMBT, I am for the nursing council.
Yes.
I am not well, my lord. Let it be on Friday so that I can be able to come to the court, my lord. I am suffering from fever.
On Friday?
That's the
Yes,
state.
my lord.
Yes.
He's the state authority.
I will file the counter. Today they have served the copy, 2 copies just now. My one learned friend said this copy. I'll take the instruction. Let me keep it to next week. I'll try to file in next week.
Next
week. Let me keep it to.
Because time is also.
My 29th is the
Possible
last
to
date.
28th, my lord.
28th.
29th is the last date.
Management quotas will be filled up by the end of this month.
That's why I made 20th or 26th. Let's say I keep it 26th.
26th. All right.
My lord, item number
top 5 cases, your lord.
Top 5 cases.
My lord, item number 65, my lord, PIL matter, my lord.
Just a minute.
65.
Just a minute. So kar dena. Which are the items? Place these matters on 26th to be taken up as the within top 5 cases. So stop. In the meanwhile, let copies of the counter affidavit be served on learned counsel representing the petitioners. Anything else?
My lord, 65 already affidavit filed, my lord.
Just a
some of the cases they file additional affidavit. We don't have some cases they file additional affidavit, or some miscases they copy didn't serve. Some 1 or 2 cases they have served the copy. Another 2 cases I didn't receive a copy. Whatever case we have received the copy, we'll file the counter. But other thing, yes,
it is indicated. It is also indicated that the parties shall be required to exchange the pleadings amongst themselves.
My lord, item 65, my lord.
Just a minute. Yes, who has joined online? Yes, sir.
Item 64. 64, I put 2 times to file the additional affidavit, additional supplementary affidavit, my lord. 64. 2 times. My lord, 65, as per my lordship direction, they file the counter affidavit.
So let it come tomorrow. Let all those matters, because
tomorrow is holiday.
Tomorrow, day after tomorrow. Tomorrow means day after.
64
matters. Those could not reach, that will pop.
Yes, automatically.
Item 64 to 2 chapter. 64. Item 64 2 chapter. I will file additional affidavit.
2 weeks supplementary. Yeah. All right. May we rise now?
Obliged.